Rise, the justices of the Appellate Division, Supreme Court First Department. All persons having business with the Appellate Division. Draw near to give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. I am about to call the calendar. When you answer the calendar, please indicate for me the time that you need today to argue your case. I would ask you to be mindful of the fact that we have a full complement of cases to be argued today, so please only ask for what you reasonably believe is necessary for you to make your point. The first case is People versus Sean White.
Respondent requests 5 minutes, Your Honor.
All right, the appellant gets 4 and 1 for rebuttal, and the respondent gets 4. Agash versus City of New York.
Appellant requests 5 and 1.
Plaintiff respondent requests 4.
You request 4?
4 minutes, Your Honor. Yeah.
Okay. All right, the appellant will get 5 and 1, and the respondent gets 4. Thank you both. All right, Sarah L. versus Panina P. The appellant gets 5 and 2, and the respondent gets 5. Labahan versus 27 Washington Square.
Good afternoon, Your Honors. The appellant requests 6 and 3.
Respondent requests 5.
5 and 2 for appellant, 5 for respondent. Cologne versus Site A, Washington Heights. And we have 2 respondents on that. So let's start with the appellant.
Appellant requests 5 and 2.
All right, first respondent.
Another respondent, I request
5
5.
and 2 for appellant, 3 each for the respondents. Vaquez versus Randall, we have 2 sets of appellants. And which appellant are you representing? Do we have the other appellant here? All right, we have no respondents. Do you still wish to argue, sir? Okay, we'll mark it submit. Thank you very much. People versus Caceres is a submit. Maghataderi versus Apis Capital. Appellant gets 5 and 2, and respondent has 5. People versus Sun Surety. Submit. Bat Brothers versus Porshak. All right, the appellant gets 4 and 1, and the respondent gets 4. Not 1, 4. That would not be right. Okay. 850 3rd Avenue versus Discovery. 5, 2, and 5. Thank you. People versus Patterson.
Appellant requests 5 and 2, please. Respondent requests 3, please.
5, 2, and 3. Thank you, counsel. Simo versus City of New York.
Counsel for the appellant, 4 and 3.
4, 2, and 4. Thank you. Talos Capital versus 257 Church Holdings.
Appellant Ashkenazi requests 6 and 2.
All right, Ashkenazi, you could have 5 and 2. The remaining appellants, 2. And respondents, you get 6. Deutsch versus City of New York. 3, 1, and 4, thank you. 3331 102nd Street versus Newport Beach, submitted. All right, the first case on the calendar, People versus Sean White. Step up, please. You can go to councils. You can go to the podium.
This is my first appeal. I apologize.
Okay, welcome.
Thank you, Your Honor.
You can proceed, Counselor.
The facts of this case,
Why don't you introduce yourself
all right.
first?
My name is Benjamin Calev on behalf of the appellant, Sean White. It's an honor to be arguing my first appeal before you guys. Thank you, guys.
It's an honor for us.
Thank
You may proceed.
In 2009, the appellant, Sean White, tragically and immaturely was involved in the killing of another person. I do not want to minimize any aspect of that because taking of a life is final. As Judge Barrett said when he denied YO in 2020, he made that point very clear, and the appellant, as well as I, agree with that. I would first say there are 3 factors and aspects of why I think YO is deserving, or in the alternative, a reduced sentence. The first is Mr. White, Sean White, sorry, because my opposing counsel is Mr. White as well. He has shown remorse. He has done it from the first day by turning himself in with his mother. He made a video confession. He took responsibility. There's nothing in the record, and I would argue that there's nothing possibly that could be argued that he has not taken responsibility. He has argued that he was intricately involved. He did shoot this person once, and again, the facts, I won't go into them, are that after years of abuse, he left his home, he encountered someone, Mr. Ortiz, who did nothing to deserve the encounter that he had befallen him, and Mr. White and his co-defendant, Mr. Larimore, proceeded to engage him. Mr. White, my client, the appellant, shot him once in the stomach and ran away, and his co-defendant shot him 5 times. Mr. White turned himself in with his mother. As I said, he made a full video confession, and again, he does not deny any of the allegations. He would, in fact, say that there's nothing he can do to take back what happened.
Sir, with respect to youthful offender treatment, is that a discretionary determination?
It is, Your Honor. And again, I don't argue against Judge Barrett's decision, per se. I would just say that in regards to the sentence, that's the juxt or the gist of what I'm arguing. I believe it is deserving of a reduction. The mitigation is the second factor. My client grew up in a very abusive household. He did not make it past the 9th grade. Again, growing up in the South Bronx, and I don't say this just to cast a shadow over anyone born in the Bronx, but he was born in very troubled times. He was abused by his parents, and I believe also by the school system that failed him miserably. He, again, shot this person once. Again, I don't minimize or take away from the fact that someone died, but this person was an immature 18-year-old with a 9th grade education. He, as a record shows, he was frightened. He shot someone. Again, Mr. Ortiz did nothing to deserve what happened to him. However, my client shot him once in the stomach and ran away. He is not a malevolent human being, as the people have tried in their response to cast him. In fact, he, for lack of a better word, was just a frightened individual. And I think that the fact that he took responsibility and showed remorse, as well as the fact that he had a very troubled upbringing, goes to show that this is not something that will repeat itself.
So, counsel,
Yes, Your Honor.
your client went up to someone who was sleeping at a bus stop, right?
Yes, Your Honor.
So how could he have been frightened? The person was sleeping. And he went up to rob him, correct?
He did not go up to rob him. I think that was actually misstated in one of the people's briefs.
What was the point of approaching the sleeping guy at the bus stop?
He just, for lack of a better term, he had just left his home where he had witnessed his mother being abused. He was in whatever a state of mind you would want to describe it. He tapped him on the shoulder with a gun, and he woke him up.
And you're saying for no reason, he just went up to a sleeping person on the bus stop and tapped him on the shoulder?
Yes, Your Honor.
Without any intention to commit any crime?
Yes, Your Honor. He, again, and I would make it clear, going to the mitigation aspect, he has no record outside of this. As I've heard a famous judge in Manhattan once say, New York Supreme Court say, he hit it out of the park on his first time. And just quickly, lastly, he has spent the last...
I'm going to let you raise that on rebuttal since your time is up. Let's hear from opposing counsel. Thank you.
Your Honor.
May it please the court, Matthew White for the people. The judgment of resentencing.
Here's my question in this case. It was a co-defendant, right?
Yes,
Who got 23 years, right?
yes.
And the question is why is Mr. White as culpable as his co-defendant who shot this victim 5 times, and it appears from the autopsy, or 4 times, that those were the 4 shots that were fatal, or one of those 4 shots was fatal?
Your Honor, the defendant instigated the incident. He approached the sleeping victim, Mr. Ortiz, at the bus stop. He hit him in the head with the gun, waking him up, and then taunted him, saying, "What the F are you looking at?" and then shot him for no reason. And then the co-defendant, who was younger, shot him 5 times. I'm not sure the autopsy revealed which bullets actually killed him. I would point out that both defendants were carrying guns that night, and when the defendant's brother asked him what happened, both defendants laughed.
Question, counsel, was this a negotiated plea?
I'm sorry, Your Honor.
Was it a negotiated plea, meaning that
Yes, Your Honor.
he was offered manslaughter, but he had been originally charged with murder?
Yes, Your Honor.
So the maximum with the murder, you have a life term at the end, correct?
Yes,
And he negotiated down from the murder 2 to the manslaughter 1 in exchange for a fixed term.
yes,
So he was no longer facing life.
correct. Right, and having sought a manslaughter plea and a fixed term, the defendant should be held to his bargain. I mean, this was a senseless and savage killing, and the defendant, had he been convicted at trial, which I submit he would have, likely would have received the maximum.
Well, sir, with respect to the interest of justice claim, excessive sentence claim, your friend raised a number of factors that he claims are suggestive that the sentence was excessive. The defendant was only 18 years old at the time of the crime. He has consistently shown remorse. The sentence he received was close to the maximum sentence for the crime to which he pled. How do you respond? What is the counterbalance, if any, to the factors that he has raised?
Your Honor, the co-defendant received the exact same sentence. It was not modified by this court. So in the interest of parity, first of all, the sentence should be affirmed. Second of all, I do have to question the defendant's sincerity in his expressions of remorse. In his motion for resentencing, the defendant stated that Mr. Ortiz jumped up in an aggressive stance, startling the defendant, at which time that it's alleged that the defendant shot 1 shot. That is not an expression of remorse. That is an excuse. Similarly, in appellant's brief, the claim is that he was shot in error or out of fear of being attacked. And there's sort of a tension between defendant's claims of remorse and mitigation. Defendant blames his neighborhood, defendant blames his parents, and yet he still claims to be remorseful. And in terms of blaming his neighborhood where he grew up, I point out that the victim in this case grew up in the exact same neighborhood. And the victim was working 2 jobs when he was killed to support his blended family of 7 children, including an unborn child that he never met. and a fiancée that he never got to marry. There are no mitigating circumstances. The sentence should be affirmed. Unless your honors have any questions, I rest on my brief.
Thank you.
Thank you.
Rebuttal.
With regards to my opposing counsel, my client's explanation or description of how he felt or perceived it has been consistent. He has not changed that from any point from 2009 to the present. I think that goes to genuineness. I don't think that goes to him trying to show lack of remorse. When I've spoken to him, and again, in the records that's been submitted, he knows that this can never be redone. This was an 18-year-old boy, in my opinion, who never got past 9th grade. His rehabilitation, though, he's achieved not only his GED, he's working towards his associates. He is geared to being a productive member of society. And more importantly, he's been in prison for 1/3 of his life. As Mr. White put in his brief, by the time he is released, he'll be almost 40. He will spend almost half his life. And I would just ask that that be taken into consideration with your decision.
Thank you.
Again, very much. This is an honor.
For us as well. Thank you both.
Thank you.
Igash versus City of New York. Step up, please.
Good afternoon. May it please the court. Patrick Lawless for the defendant's appellants. The court below erred in denying the defendant's summary judgment motion, as the evidence clearly shows that the independent contractor, Yonkers Contracting, was responsible for directing and controlling the work, and that neither the city, the MTA, or the transit authority supervised or controlled any of the work that was being performed at the site. At most, the city and the MTA exercised general supervisory authority and performed safety inspections, but that's not enough to establish that they supervised and controlled the work, which would make them liable. Also, there's no evidence that, with respect to the transit authority and the MTA, that they had any non-delegable duty because they did not own the property. With respect to the city, in order to hold the city liable because they didn't supervise and control the work, it would have to be shown that they were aware of a dangerous condition on the premises, which there's no evidence in this record.
So, counsel, let me ask you this. The transit and the MTA set up a field office right by the project, right? Correct?
Yes.
They were at the site every day, correct?
Yes.
They often for several days, hours a day, correct? And they did multiple site safety inspections and site reports, and you're saying none of that raises an issue of fact?
No, I mean, the case law is clear. That's not sufficient.
No. The case law is, sure, I controlled general supervisory authority, but I'm there every day. I'm doing multiple reports about site safety. I have a little kiosk a block away. That you don't think raises any issue about supervisory control?
No, because that doesn't...
Well, why were they there then? Why were they there every day?
But they did not supervise or control the work that was being performed.
Oh, I know that that's what you're saying, but I'm saying to you, why would they be there otherwise?
All they were doing was just they were there for
Observing?
quality assurance and to check on the progress of the work. And they did perform safety inspections, but that's not sufficient to show that they had sufficient control and supervision over the work to be liable.
I'm not saying it's a summary judgment, right? The plaintiff hasn't moved for summary judgment, but you wouldn't even agree that that at least raises an issue of fact where the owner is on the site every day, has a kiosk a block away, is writing multiple safety site inspection reports, that doesn't at least raise an issue of fact?
No, that doesn't raise an issue of fact because, again, all it does is show that at most they had general supervisory authority, performed safety inspections and quality control, but they didn't supervise or direct controlled the actual work that was being performed.
If the renovation work posed an inherent danger, isn't that another basis on which your client could possibly be held liable for this accident?
There's no evidence in this record that this work was inherently dangerous. The cases that are cited by the plaintiff are completely different. This isn't a case where there was material being hoisted above the public's.
There was material that was improperly secured. I mean, a metal object, let's just call it something used for the renovation work, at the elevation, which should have been secured, was not, and fell down and hit a pedestrian. That doesn't make it inherently dangerous, the failure to secure the work site that's above the heads of pedestrians?
That doesn't raise to the level of inherently dangerous work. There's no evidence that that had happened before or that it was inherently dangerous. And all the, in the safety reports, there's all these issues that are cited by the plaintiff were resolved or completely irrelevant. And again, it wasn't a case where they were constructing a sidewalk shed above the public's head or they were hoisting materials. Yeah, but it's just something that was left out that apparently fell, but it was a piece of metal that fell, but we don't know where it came from.
Counsel, there were safety reports that indicated that your site inspectors found Yonkers did not have appropriate netting to secure materials on top from falling, among the other violations or issues. So we have a situation where a construction tool, as described in the depositions as a nail puller by one of the witnesses, a heavy metal claw that fell from an elevated site. By the way, pedestrians were redirected to that area to be able to board buses, if I'm not mistaken, which would be under your client's jurisdiction, correct? In terms of routing the public to be able to board under this elevation, which your site inspectors found was a dangerous situation with respect to the potential for falling objects, which is exactly what occurred here. So as my learned colleague pointed out, you don't think that's inherently dangerous, and there's a concern where you had a responsibility in maintaining safety to the public to have that kind of duty to prevent such inherent dangerous conditions as this falling object?
If I may, I see my time is up. May I just
You can certainly answer my colleague's question.
I believe the reference in the report to netting had to do with fall protection for the workers and not materials. There was a reference about that workers were working above an area that there was a gap, but then right next to that in the same report, it says that that was resolved that same day, and this was prior to the incident. So there's no evidence that any tools or anything were falling prior to this incident, or that there was a danger that they would fall to the pavement below. All these issues were addressed and resolved prior to this incident. And again, my recollection is the reference to the netting had to do with fall protection for workers and not based upon the danger of tools falling to the ground.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honors. On behalf of Plaintiff Appellant, I would like to just quickly remind the court what the facts are of this case. Plaintiff went to use the number 6 train at the Castle Hill train station on the date of this accident and was redirected by the defendants to leave the train station and wait for a shuttle bus underneath the location where this work was being performed. She was struck on the head by a tool from the defendant's work site while she was waiting for that shuttle bus. She was on the ground with the tool beside her when the defendant's contractors came and retrieved that tool. We should be here today arguing and establishing that it is plaintiff who is entitled to summary judgment. It just so happens that these are the defendants who are in front of this court because these defendants didn't bother to figure out precisely how this accident could have happened. A metal crowbar fell from the train tracks and struck plaintiff while she was standing there with her children waiting for the bus. The defendants are potentially responsible on the basis of 4 bases. Number 1, clearly this was inherent dangerous work that these contractors were doing at the defendant's direction. They were performing work on an elevated train station in the Bronx over a public sidewalk. Number 2, it was on a sidewalk. Therefore, there's a non-delegable duty. Number 3, this is inherently dangerous work. I don't know if I did that one already, sorry. Lastly, your honors recognize that there are references in the defendant's 100 pages of records that show that the defendant knew that these contractors were negligently conducting the work. They were exposing the public to overhead hazards. It's in the defendant's own records. We are here today on the defendant's motion for summary judgment, and they have failed to prove how they could not be liable based upon these set of facts. If there are no questions, I will sit down and let you think about more important things than the defendant's entitlement to summary judgment.
Rebuttal?
Again, with respect to the non-delegable duty, does not apply to the MTA or the transit authority because they did not own the premises. The reports that are being referred to, many of those reports actually refer to a different site than this one, so that's not sufficient to put the defendants on notice. And again, the evidence shows that the defendants didn't supervise or control the work.
So I'm looking at the report from the day of the accident, and on that report, it says that I noticed, your person, I noticed a bunch of things wrong, and I discussed it with Yonkers, and we talked about how to remedy it. And then on the next page, and that day, that same day, there was an accident, and the woman was hit with the claw. You're saying that still doesn't raise an issue of fact as to whether or not you had sufficient supervisory control over that premises on the day of the accident to impute liability?
I believe that report that you're referring to, there's photographs, and one of the photographs says that the issue was resolved.
I have to say, I can't tell from the photographs. They're pretty bad photographs.
Yeah.
Okay.
Thank you.
Okay, thank you. Thank you both. Sarah L. versus Panina P.
Good morning, Your Honor, or good afternoon, Your Honors. Pleasure to be here today. Thank you for your time. May it please the court, my name is Nicole Trivelis. I'm with Rosenfeld and Vallejo Justine, attorney for the appellant. This matter arises from the lower court abusing its discretion in directing appellant to pay 43% of child care, unreimbursed medical expenses, and educational expenses, including private school, for the now 6-year-old child that she shares with respondent, and whom respondent has sole decision-making. In making this direction, the lower court effectively directed appellant to pay 1/2 of her net income for the subject child and left appellant in a position where she cannot afford to meet her monthly expenses or the monthly expenses of her 2 other children who were conceived through IVF prior to the parties' relationship, and the appellant is fully responsible for supporting. These 2 children are now 10 and 13, and in its direction, the lower court failed to take into consideration the real-world effects of its order. They failed to take into consideration the dire financial situation that it puts appellant in, and they also failed to take into consideration the disparate financial circumstances between the parties. Appellant is a W-2 employee who makes less than $200,000 a year, approximately $180,000 a year. With this income, she has to now support 2 children fully and the subject child. As a result of the parties separating, appellant has had to change her lifestyle drastically. She's had to move out to New Jersey, enroll her two other children in public school, and she's accumulated substantial debt. On the other hand, respondent's life remains unchanged. She resides in the same home, in the same building that she has resided in prior to the parties' relationship. It's a luxury apartment located in Central Park South, where appellant currently pays $8,500 a month in rent alone, which is approximately where respondent pays $8,500 a month alone, which is approximately what appellant nets per month in income. In making the determination, the lower court failed to take in consideration the substantial expenses that the respondent is paying per month. If you look at the record, respondent stated that she spends approximately $20,000 a month in expenses, which equates to about $240,000 a year, yet the lower court only imputed her income at approximately $240,000. The lower court also failed to take in consideration that the respondent has $4 million in resources, and failed to take in consideration that the situation that it's going to present to respondent.
Counsel, what, if any, evidence was adduced below regarding the parties' expectations as to who would pay for Maxine's education?
It was my client's understanding that she would not have to contribute towards private school, which was discussed at trial. When the parties were together, she could not even afford the full cost of school for her two children who were enrolled at that time. The testimony shows that respondent even contributed towards those expenses. So it was never my client, according to her testimony, expectation that this would be an expense that she would have to contribute to, because it would be financially impossible for her to make that concession. She doesn't have the resources. I mean, I think logically and without, obviously everybody makes different incomes, but I think most people in this real world can understand what it's like to make less than $200,000 in the tri-state area and having to care for two children, let alone a third child. And the lower court's award puts appellant in a position where now she has to expend more resources towards one child at the detriment of her other two children. And these two children have to be enrolled in public school, and it's illogical and it's unfair to say that their sister can now attend private school. And respectfully, the lower court's determination did not present a justifiable basis in directing appellant to pay this. 43% of educational expenses at private school are not something that a court is mandated to direct, and they did it here. Based upon appellant's income and being left with barely enough to cover her food, her housing, transportation, let alone all the daily things that come up in life, and let alone all the expenses for her two other children, such as clothing and tutoring. One of her children has selective mutism, another factor discussed during the trial, which was not brought up in the decision. So there's extra money that has to be expended on her. So leaving appellant in a position where she cannot afford to pay for her daily resources is contrary to, I submit, this court's prior rulings. Even in Michael v. Carolina, this court in 2016 held that...
Your time is up, so I'm going to ask you to reserve that for your rebuttal.
Absolutely, Your Honor. Thank you.
Good afternoon, Your Honors. Michael Beda for the respondent, Sarah Lipman. For starters, the lower court did not abuse its discretion.
Well, clearly you're going to say that, but what I really want to know from you, tell me how these numbers work out.
Sure.
Yeah, I mean, because that seems to be at the core of the arguments here, that this is unaffordable for the appellant. Is it unaffordable for her?
It is not unaffordable for the appellant, and the lower court specifically went out of its way to indicate in its decision that to make it affordable, we're going to cap the child support that the appellant is paying at the $154,000.
Well, that's for the basic child support. She left it at the statutory cap. The relative percentages were based upon the incomes that were otherwise reported. So based on those numbers, and given what private school in Manhattan costs, is it affordable?
The answer is yes.
Tell me
And
how.
Based on the appellant's income, which was lower before the parties separated, the appellant was actually paying in the last year that her two children were enrolled in private school, $27,400 for those two alone.
Yeah, but we don't know that that disposable income, now that they're living apart, isn't otherwise being used for other things, like rent. I mean, they did live in your client's apartment, which was, I think, provided by her family. So now, based on the income she has, and I guess there should be some imputed income because she, like your client, got a lot of family money, although it's unclear to me how much family money each one of these litigants actually got. It seems the lifestyle they were living kind of exceeded both of their incomes. Yeah. So explain that to me, just by the numbers.
Sure, so by the numbers,
Yeah.
the lower court imputed income to the respondent, bringing her income up for the income that she was not receiving from her rental property because of the renovations being made at the time. The court took the base salary of the appellant, factored in, then combined that parental income, arrived at the pro rata share like Your Honor stated.
Right.
Working from there, the record clearly went, or during the trial in this matter, Your Honor, the 12 days of trial, both parties set forth their own expenses. The expenses that were delineated by the appellant were horseback riding, therapy for her child that's covered by insurance, gymnastics, and some tutoring for school. That's what's in the record regarding the expenses that the appellant has for her children. She also has a housing expense, obviously, of approximately $2,900 that she pays to her sister. That $2,900 is approximately the same amount of money that was being paid to the respondent when the parties were residing together in Manhattan while the appellant was paying $27,000, or actually, while the appellant was paying for private school tuition for her older child. Now,
So, counsel, and her children are now not in private school, right? They're in public school.
that's correct.
And since she has, and I don't think there's any dispute that she said she can't afford to put her two children, her children who are not your client's children, in private school. So what would happen, I suppose, is she would be required to pay for one child's private school education, and the other two children of hers would not be entitled, would not have that private school education. That's what you're advocating for, correct?
That's correct. The facts of
Okay.
the case, Your Honor, went to the parties when they were
And just
residing
remind
together.
me, how much is Brearley? I think your client wants to send their child to Brearley, correct?
That's
How
correct.
much is that a year?
It's approximately $50,000 per year, of which the amount that the appellant would be paying is actually less than the amount that she paid for her two children in the last year that they were residing in Manhattan, and she sent them to private school.
Right, but those were different circumstances, right? She wasn't paying housing. Your client paid for a nanny. There were plenty of, those were completely different circumstances, right?
Respectfully, the circumstances were not that completely different because the appellant was contributing to housing expenses for the parties, approximately the same amount that she's paying right now to her sister for her rent. The appellant, in fact, by not paying for private school right now, has the available resources to pay for their child's private school, which was their intention to send her to private school. And the lower court went over the issues, and we addressed the parties' intentions in detail during the trial, and the lower...
Yeah, the intentions, there's no question. That's what the Superior Magistrate said. It was their intention. But the argument here is, as good as your intentions may be, is it otherwise affordable? All right, let's hear from, Well, that's not a question. I guess it was, but it's rhetorical. It's not really answerable. Okay, so let's hear from your adversary in rebuttal. By the way, you don't dispute that when they were intact, that it was the intention of both of these parents to send this little girl to private school in Manhattan.
I believe it was always respondent's intention to send this child to private school. She comes from private school education.
Yeah, we know
boarding
that.
school.
That's easy. That's an easy way to answer my question, and quite frankly, not a fair way either. Your client expressed her intention. She wanted to send her child to private school, right? Your argument is all things being equal, if they had unlimited money, or if respondents said, I will pay 100%, your client would happily send her to private school. Isn't that so? Doesn't the record reflect that?
If financial constraints weren't an issue, then yes, it would be potentially, obviously, she'd want the best for the child.
Right, so your sole argument here is that it's unaffordable for her. Is that your argument?
Yes, Your Honor, it is unaffordable. I see my time is up, so if there's no other questions.
We're good. Thank you both.
Okay, thank you, Your Honor.
LeBahan versus 27 Washington Square.
Good afternoon, Your Honors. Magda Cruz on behalf of the appellant, New York University. In this appeal concerning a complaint that seeks to enforce a handwritten rent overcharge decision that was entered in another action upon default against a predecessor owner that was twice removed from the university, at issue is whether there's any legally cognizable claim asserted against the university for the concept of carryover liability. And I submit that the lower court did not correctly determine that there were any facts in the complaint alleged showing the elements of carryover liability as to New York University.
Ms. Cruz, was the NYU taking title pursuant to a judicial sale or an auction?
No, it was not.
So isn't that the only, I haven't looked at, well, I looked at the section here, but based on the historic analysis of that rent stabilization code section, but wasn't that pretty much the only type of sale that would give a successor owner a path to avoid carryover liability?
No, Your Honor, that's not the only path. As I outlined in my reply brief especially, where I submitted a number of cases both from this department and the second department, the critical elements are, number one, that there is an actual judgment that was entered against the predecessor owner. That does not exist here. It is not alleged that it exists here. And clearly it was an error by the lower court to have determined on the record that there was a judgment. There was not a judgment here. And number two, that the...
Well, counsel, we agree there was an order directing entry of a judgment.
Yes,
correct?
there was a handwritten order directing entry.
Well, I mean, every order back then was a handwritten. I don't know why you find that an interesting thing. No one, I mean, so what?
No.
The judge wrote,
yeah,
enter judgment, correct?
Correct.
So, I mean, that means that doesn't, the fact that the judge wrote it rather than typing has no significance, correct?
It does have a significance here because the judge also indicated and directed the plaintiff to settle the order in order for it to become effective so that the clerk would know what to enter, Your Honor.
The handwritten order says settle order?
Yes, it does. At the bottom, if you look at page 49 of the record, it says clearly settle order. the box next to that typewritten indicator is checked off. That was an indication that this handwritten order, page 49 of the record, barely legible, could not be effectuated by the clerk until there was an actual process to indicate what exactly was to be entered, what amount, for what money, for what reasons. So that, and a successor owner that was not a party to the action, that was never notified of this, that there was no...
Well, so, okay, so that's your, here we are, we're at a pre-answer motion to dismiss, right?
Yes.
So the complaint alleges that you are responsible, you knew or should have known. If you had done a proper investigation, you would have known. And you say, no, I wouldn't. But is this the appropriate time for us to dismiss the lawsuit in that event?
Yes, because the complaint does not even say, Your Honor, that my client had any possible knowledge. Doesn't say that my client had knowledge or could have had knowledge upon doing a due diligence, which of course my client did upon buying this building. The reason the complaint...
So you're saying if you put in the address of the property in a search on e-filing, you wouldn't have come up with the lawsuit?
No, it would not have come up because this lawsuit, A, had ended a long time ago, years before, number one, and number two, this order did not appear. In the record, we reproduced the docket, and a rent overcharge order did not appear. And of course, there's no judgment docketed.
Yeah, but so let's assume for a minute that if you search the court files, you weren't going to be able to find it, or a title search. But in terms of the transaction that you engaged in, if the files at closing, which were the building files, were transferred to you, how do we know that you didn't have notice of what was going on from those kinds of files, which typically would include this information?
Yeah, for two reasons. Number one, the complaint does not allege that my client had knowledge or constructive knowledge. And in fact, it is confirmed because the plaintiff admits it did not even learn of this order until a year after my client purchased the property. So if the plaintiff...
Well, he didn't have the building files. That doesn't mean you didn't know about it. That doesn't mean much to me. And the pleading error, assuming it is a pleading error, that's easily amendable. It came up in the context of this motion. So that to me is sort of a technical reason that I have to say doesn't really appeal to me as a judge. Tell me why there isn't at least a question at this point in the proceeding about whether you knew about this.
Or
should have known about it because you purchased the building.
To what you said earlier about the building files. Would it have appeared under a normal, transaction?
A transfer, at closing, you get the building's files.
Right. So, first of all, my client, New York University, did not buy the building from that predecessor owner. There was an intervening owner.
I know, but they seem to have some affiliation.
They had no affiliation, Your Honor.
Turned over almost immediately. And besides which, that doesn't stop the turning over of the files. And we just don't know enough now, do we?
Well, this order would not have appeared in the building files because at the time of the transfer, the plaintiff did not even have it. He admitted he did not have it. Therefore, if the plaintiff didn't have it,
they were parties to the litigation. They were following along. They were served. I mean, whatever. Okay, I understand your point. Okay, let's hear from the other side.
Good afternoon, Your Honors. It's an absolute pleasure to be here. I am Mark Davies for the plaintiff in this matter.
I like that everybody is so happy to be here today. It's good.
It's a bright, sunny day.
It is. We like being here.
It's that summer feeling coming on. Okay. Now, One thing that I do want to just address very quickly from what she said is this idea that she continually has hit within her papers that there should be some kind of notice provision, that the fact that she didn't have actual knowledge of this lawsuit somehow affects the legal precedent and the carryover liability that she holds. The statute is very clear, and this court touched on it earlier. The only time notice becomes important to this particular carryover liability is in the event of a judicial sale due to bankruptcy or mortgage foreclosure, et cetera. It is not applicable in this instance. There is no notice provision that comes along with this statute.
Would it apply, though, or would it have some relevance to the fact that there's some component of treble damages in the overcharge complaint that
Well,
your client is
there may have
trying
been
to
a
enforce?
request for treble damages in the overcharge complaint, but there, in my reading of the decision, I didn't see the judge actually apply treble damages. He did not notate an application of treble damages, and therefore the notice provision becomes direct overcharge.
So you think that that amount is just strictly overcharge?
Yes, I believe that was approximately the 7 years of overcharge differentiation between the 2,000 and I believe nearly 4,000 in rent that my clients paid. So I don't believe treble damages was issued in this matter.
So let me just ask you, do you agree with counsel that the judge's order required you to settle an order?
I don't really agree with that, to be honest. I received
what
a
does
lot of
he-
those old paper writings,
Right.
and judges would many times tick that off. And generally, it was not required to settle when you have that nice clean-cut order that says, this is the amount of money that's owed, enter a judgment. You know, it's something that I brought up in my papers under the Funk case, which basically, when you have an order that stands on its own and is self-explanatory as a simple, this is the amount of money you have a judgment for, there is no reason to go and settle the order. I don't need to type it up officially.
And the order did, in fact, tell the clerk to enter the judgment.
Exactly. So even if there was supposed to be an additional settlement of that order, the direction of the court was still clear that it should have been entered as a judgment. Now, I don't know what happened. This is one of the old paper cases about 3 years into the e-filing times, so I'm guessing that something must have fallen through the cracks there. Unfortunately, it was a little bit common sometimes, and
All right, let's just leave aside that, and let's get to the issue of known or should have known. Do you or do you not concede that there would be nothing, if you did a title search here, or you did a judgment search here, that the owner, NYU, wouldn't have found this, any document indicating that there was an order directing an overcharged judgment? That's not where they would get their knowledge from.
well, there's a lot of different ways to research and look into a building. The fact is, when they purchased it, there would have been a litigation on the building just a year or two previously. The fact that they didn't look into previous litigations, you know, what is the limits of due diligence? What
Well,
we're saying
absent
here
a
is,
Liz Penn's, how would you search for lawsuits against a property?
well, you have, the
Defendant would be
lawsuit was
named as
against
a
the
party.
previous owner.
Sorry.
And simply by searching for the previous owner in any kind of legal database, I believe you can pull it up on NYSEF, actually, just by name, even if it does not technically or exist under the e-filing system, because it would have been under the e-court system.
That may be a reasonable search if the search returns 5 hits. It may be unreasonable if it returns 500.
Well, again, I will raise to the court that the
In the
reasonableness...
general, in the general course of a real estate action, you're not doing that kind of extensive search. You get a title search, right? Would that be part of a regular?
Generally, you do get a title search. When you're talking one of these large multi-million-dollar buildings, usually there is additional research done. As other cases have presented, generally it's good form to go to the DHCR, look for previous proceedings, active proceedings, and look at the actual reports to see what your liability might be on any given unit. And that's something that's been specifically directed by the court in these matters.
So, counsel, let me ask you this. Are you stating that you can tell as a matter of law from the decision in order of the judge in the 2010 action that he didn't award, or she, I think it was he, right, didn't award treble damages?
I
I
did-
see no notation that treble
Either
damages
way,
were
though,
awarded.
correct? Either
And
way.
I see the numbers that my client paid in rent, and I see the declaration that it's about 2,000 is the registered rent, and the difference is approximately what the court had there, so I assume there's no treble damages. But where the court is silent on the matter, I can't make a final determination
So
personally.
just for assumption's sake, if there were a component of that that were treble damages, then that would differentiate at least that portion of the damages from your argument that the regulation only deals with a judgment, right? The
Yeah,
treble
certain punitive damages do require notice in order to transfer over. And we could, of course, and this is where we get into what the court was talking about earlier, where once we look at what they actually knew when they purchased, then we can determine whether the treble damages would be able to carry over. But at this time, just based on no knowledge, we unfortunately cannot do that. There are still large issues of fact here.
One last question. Your adversary raised an issue about a defect in your pleadings for not otherwise alleging the notice component. Is that a defect that would warrant dismissal?
A, I don't believe it's a defect that would warrant dismissal. B, I don't think it's a defect. There is no notice provision for this carryover liability. To say that they have to have notice, there's nothing in the statute, there's nothing in the case law that says they get notice or else they don't have carryover liability. No, we don't need to allege that in the complaint. Thank you very much.
All right, rebuttal, please.
I'd like to reply to a couple of things, but to begin, a statement by Mr. Davies that the law does not require notice, that is categorically incorrect. At page 12 of my reply brief, I discuss at length a case called Helfand versus Sessler. This is by this department, in which, in this case, the court found that there was liability because and it went through very carefully the reasons why. And most notably, it stated that the carryover liability provision is an exceptional remedy that is intended to ensure that tenants are not divested of rights because either there's a fraudulent transfer or that there is in some way a reason why they have, the rent overcharges were actually charged and knowledgeable to the successor owner. And there was a relationship found in that case.
Well, interestingly, though, the carryover liability statute doesn't require notice. It almost speaks in absolute terms.
The regulation does not, Your Honor. That is correct. But the case law that has developed, because it is such an exceptional remedy, has indicated, as I stated in my main argument, you need to have an actual judgment. It has to be docketed. And there has to be some degree of constructive or actual knowledge. The constructive notice is a more difficult concept, but here we do not have either. The complaint does not allege there was any. It is impossible for my client to have had knowledge. I indicated there was a due diligence. My client is a major university in this city. It clearly had good lawyers, and in this case, it did its due diligence. It had a title search conducted.
I mean, counsel, isn't that all facts that have to come out in discovery? How can you say that as a matter of law? How can you say that now?
Because the complaint does not allege it, Your Honor. Not only that,
how is the plaintiff going to know whether or not you did a good enough search on a pre-answer motion to dismiss?
Because, Your Honor, although that is, as Judge Gish indicated, something that's technical and could possibly be amended, here it's not the only thing that the complaint did not allege. There is no judgment. There is no notice, no constructive notice. There was no relationship alleged, nor is there.
Isn't that because their theory is that under the statute, there are no common law exceptions that you're now putting forward. So I don't know that, and maybe I use the word technical inadvisedly. I think that their complaint certainly seems consistent with their theory of what the law is, and you're raising, quite frankly, the issue of notice and the common law exception as your defense here. And I think that to sort of say, because they don't have it in their complaint, that they're out of the box, period, doesn't hit me as being correct.
But Your
But
Honor,
we'll
that's
look
not
at
the
it.
only reason. My main reason is that there was no judgment entered in this case. Thank you, Your Honor.
Understood. Thank you. Thank you both. Cologne versus Site A. Okay, you can proceed.
Good afternoon again.
Again?
May it please the court.
Yeah.
Patrick Lawless
Yeah.
for the defendant, third-party plaintiffs, appellants, who respectfully request that this court reverse the order of the Supreme Court which denied their motion for summary judgment and granted the plaintiff's cross motion to amend a complaint. First and foremost, the cross motion to amend a complaint was defective. All it contained was an affirmation by counsel, not an affidavit by the plaintiff. There was no explanation why it took 5 years to correct the date of the accident. The proposed pleading was not attached to it. Plaintiff claims that it just was merely seeking to conform the pleadings to the proof, but if you look at the proof, it doesn't conform, because according to the plaintiff's testimony, the storm began at 8:30 a.m. when the certified weather records show that it didn't start snowing until 11:30 a.m. on March 20th. And also the plaintiff testified that at that particular point in time, he only would be at that location on Thursdays, where March 20th was a Friday.
Those are all fair points, sir, but I mean, the touchstone under 3025 for prejudice is whether you were hindered in your defense of the action, and you seem to address each of the various scenarios on the merits that may have unfolded. And so, I'm just curious if you want to talk about the merits of your motion, because you seem to have addressed each of the various factual permutations.
I was going to say, in any event, even assuming that the accident took place on March 20th, it's clear that there was a storm in progress. And in opposition to the evidence that there was a storm in progress, the plaintiff failed to raise an issue of fact. Again, the meteorological evidence shows that it began snowing continuously from 11:30 a.m. until just before midnight that day on March 20th. The plaintiff claims the accident happened at around 1:45 p.m. It was still snowing at that time. So therefore, it was up to the plaintiff to come forward with evidence that the defendant somehow made the naturally occurring condition worse, which he failed to do. The plaintiff claims that he slipped and fell on black ice, and he also claims that he saw building personnel shoveling, but he claims that they were shoveling at 8:30 a.m. when no snow was falling. He also overlooks the testimony of Mr. Altshu, the expert meteorologist, and the certified weather records, which showed that at that time, the temperature remained above freezing up until 1:45 p.m. So there was no possibility that any ice could have formed at any time prior to that time.
Did it snow the day or days before?
No, there was no pre-existing ice. That's what the meteorological evidence shows, and that's what Mr. Altshu's testimony, his affidavit shows, that there was no pre-existing ice. So this isn't a case where there was a prior storm and there was melt and refreeze. There just was no pre-existing ice on any surfaces prior to this incident. So based upon that, and the plaintiff's failure to come forward with any evidence that the condition was made worse, by snow removal efforts, summary judgment should have been granted. And I'll just move on to the issue of indemnification. The indemnification agreement states that the tenant is responsible for indemnifying Site A.
But is the tenant responsible for snow removal in the area where the accident occurred?
No, I don't think that's relevant because it says.
Well, to answer the question first, and then you could tell me why it's not relevant.
Well, okay.
I mean, you concede, they're not responsible.
They're not responsible, but there's.
So why doesn't that make a difference in terms of the indemnification?
It doesn't make a difference in terms of indemnification because the indemnification provision says the use and occupancy of the premises. And at the time, in connection with the use and occupancy, and at the time of the incident, the plaintiff testified he was transporting a client to and from a bus stop, and he was returning from that. So it's still connected with the use and occupancy of the premises. It's almost the equivalent of arising out of the work, but it's the use and occupancy of the premises.
Except that that's not the standard. It's not arising out of, that's a different standard.
But it's the use.
In a different context, this is a lease.
It's a lease with an insurance procurement provision, but it's also arising out of the use and occupancy of the premises. So whether or not the tenant had a duty to remove snow is irrelevant, but in any event, the tenant's own witness testified that they did that anyhow, whether they were obligated to or not.
Okay, thank you. You may proceed.
Please, court, and Your Honor, Brandon Cotter, Hackett and Rose for the plaintiffs. Your Honor, there are time for appeals and there are time for trials, and this case is begging for a trial. Your Honor said it as best as I could. There are various factual circumstances in this case, all of which need to be fleshed out by a jury.
Let me just ask you this. Is there any dispute that there was a storm in progress when your client fell?
I don't think there's a reasonable dispute that there is a storm in progress. I think that
There was right, we all agree there's a storm in progress. So we start from the proposition that storm in progress, no liability. So from that, where do you go?
There are two places that I go. The first one is to talk about the storm progress in and of itself. And page 326 and 350 of the record are particularly important here. And that's because the plaintiff, when he arrived, saw the exact same condition of ice on the ground when he arrived and saw the plows.
Well, it was snowing when he arrived, right?
And ice.
Okay. Did he say that he saw it any other day before that?
He did not say that he saw it.
Did anybody else say that they saw it any other day before
I think what's particularly important with that, Your Honor.
I just want to ask you whether or not anyone else testified to that.
No one else testified.
And the only evidence we have is from an expert who said there was no ice before there, it wasn't snowing. So your client says there's no ice beforehand, no other person says there's snow and ice beforehand, the expert says no snow and ice beforehand.
That's
correct?
not completely accurate, Your Honor.
So what am I missing?
Sure. With regard to that particular issue, there is evidence in the expert meteorologist report that while there was not active precipitation, there was snow on the ground.
No, ice. Your client said he slipped on black ice.
Your Honor,
So I'm asking you, and there was clear, I mean, that's what the expert says. There's no ice beforehand. Do you dispute that?
I don't disagree with what the expert says.
So what evidence did your client put in to refute all of that?
There are two separate issues with regard to that evidence, Your Honor. With regard to the storm in progress issue, the ice that matters is the ice that he saw in the morning because it was the same ice that caused his fall. And that ice was there when the plowing was being done. If that was being done correctly and non-negligently, there would have been no ice later on for him to fall.
Do you have an affidavit from an expert to say that somehow when they were cleaning the snow from the premises, that they did that negligently?
There is no affidavit because we don't know everything that they did. What we do know is the result of that, which was there was ice on the ground. And I submit to you that if I had to sweep up glass on the floor and when I left there was still glass on the floor, then I didn't do a very good job.
But is that enough in this context? I mean, in most negligence contexts, that might be enough. Isn't something more required here, that they create a hazardous condition or exacerbate a pre-existing hazardous condition?
In the line of cases that we cited, there's an indication that the fact that they failed to do the job properly, meaning that they left over remnants, means that that is going to be enough. I think that in and of itself is enough. To address the second portion of that, Your Honor, and to go back to your question about a possible pre-existing condition, the issue that does exist, that has not really been addressed, but exists within the record, is that there was pre-existing standing snow on the ground in the days before. There was heating, there was cooling, and there was testimony about the manner in which these folks cleared this area, specifically that they would only plow a particular path, leaving snow to each side. So, to the extent that you want to get into the constructive argument to address what may have been on the ground before, the reason why
No,
there's
there is no evidence there was anything on the ground before. All you're talking about is some other stuff. Your client himself didn't even testify that there was anything on the ground before the day of the accident. Right?
What he was asked.
No one else, you didn't put in a single affidavit from anybody else saying any of that. All you're talking about is somewhere, somehow, there was precipitation.
What he was asked is whether or not there was snow on the days before. And there is no doubt that there was no active precipitation on the day before, but that does not mean that the record does not show a possible condition. That being said, the main crux of my argument is the fact that if you're supposed to plow, and you're supposed to sand, and you're supposed to salt, and you don't do those things and ice is left over, you've done a poor job. And that's really what happened here.
Okay, thank you. Let's hear from the co-respondent.
May it please the court. I represent the respondent aid services, and with respect to the issues being brought to the court today, I'm here just to touch upon the indemnification one. In October of 2019, Judge Billings issued a decision on my client's motion for penalties due to the appellant's failure to produce any employees who were working at the time of the accident. In doing so, Judge Billings granted my motion and precluded them from presenting any witnesses, and also analyzed the lease and found that the appellant may not rely on the lease exclusively because it imposed responsibility on the tenant only to maintain the sidewalk and the area adjacent to the doorway, not the other public exterior portions of the premises. Specifically, they were not responsible to remove snow or ice from the parking lot area where the plaintiff fell. At no time after Judge Billings' decision was issued did the appellant ever notice an appeal to decide whether or not her decision was incorrect.
Counsel, how do you respond to your friend's point that taking that language as you read it and not doing any violence to Judge Billings' findings, that in effect this negligent, or I'm sorry, this hazardous condition arose out of your own operations, your own use of the driveway?
Well, that's misplaced because the lease also goes on to define what the demise premises is, which is the portion in which he is citing to involving the manner and occupancy, and that does not include the area where the plaintiff fell. The demise premises is limited just to the interior portions of the property. Therefore, his argument that it arises out of the manner and occupancy is irrelevant here because it's not a part of the contractual agreement which defines what the demise premises is, which would trigger the indemnification. The relevant indemnification clause also mentions that they have to show that they're free from negligence in order to be indemnified by my client. They haven't done that.
So if, say, for instance, because one of the issues that is the core of this appeal is whether they are, whether they're negligent or not negligent under the storm in progress doctrine, right? That's between the plaintiff and them. I don't know, you know, let me step back from that, what I don't know. So if in fact the storm in progress doctrine shields them from liability, doesn't that mean they're free from negligence under the indemnification clause?
Well, and if that's the argument, I would also be free from negligence under the storm in progress defense. Isn't that correct?
I'm not
I
answering
concur in
here,
that
I'm
aspect.
asking.
We're
In that
asking
aspect of,
questions here.
in that aspect of the appeal, I concur that if the storm in progress defense is applicable, if we agree that that was when the accident occurred,
Then it
then I would
goes
join in
across
that.
the board.
What's that?
Then it goes across the board.
Correct.
Okay. Okay.
Thank you.
Thank you. Thank you.
Just very briefly, I'd just like to address, there's absolutely no evidence in this record, and it was never refuted in the court below. The evidence and the statement by the expert that there was absolutely no ice present on any surfaces prior to the date of the storm. There was no evidence in this record of any existing snow or melt or refreeze. That's just not part of this record. And with respect to the issue of indemnification, regardless of the storm in progress defense, again, it just arises out of the use and occupancy of the premises. And at the time, it is in connection with the tenant's use and occupancy of the
I
premises.
know you say that, I just don't know how far that goes. You say it's because he was walking a patient to the driveway. Suppose it were the bus stop. Suppose he took the patient on the bus. Would that be in connection with and an accident occurred while they were on the bus? You mean to tell me that, I just don't understand the concept of how far that indemnification
Well,
goes.
it was in connection with, I mean, the use and occupancy, you know, the tenant
Was he counseling him as he was walking to the?
Well, it was, you know, apparently part of the services that they were providing, and he was,
Why would that be part of the services? He was just being a nice guy walking to the bus.
I would say it was in connection with the use and occupancy, in connection with the work. But other than that, I'll just rest on my brief. Thank you.
Thank you. Moghaddatera versus Apis or Apis. I apologize if I mispronounced that. Okay, Counselor, you can proceed.
Good afternoon, Your Honors. May it please the Court, my name is Donna Mulatto on behalf of Appellant Cameron Moghadiri. Respondent's motion to dismiss should not have been granted for 3 reasons. First, the lower court did not accept the appellant's factual allegations as true when it failed to acknowledge the material ambiguity within the 4 corners of Addendum B to the agreement with respect to the conflicting definitions of excess net income, which made E&I susceptible to more than one interpretation for a withdrawal members payout.
I'm sorry, so E&I is defined in 1.09A as an apple, right? It's expressly defined there.
Yes.
And then there's a spreadsheet, that's the
word,
where the label we're slapping on
Yes,
it?
there is a Schedule E within Addendum B.
And so can the material, the content of that spreadsheet upset the express definition that's in 1.09?
Yes, they are conflicting. So the schedule contains words and numbers that clearly defines the definition of excess net income, and it conflicts with the definition in Section 109, both of which are in Addendum B. This results in 2 different calculations for a withdrawn member's payout, which is ambiguous within the Addendum B. Addendum B is the only is the only addendum that deals with the treatment of a withdrawn member's payouts, and is the only addendum that contains the definitions of excess net income.
Didn't the, counsel, didn't the defendant actually acknowledge this tension?
Yes, as a matter of fact.
And that generated a 2017 letter?
Yes, exactly. As a matter of fact, the irreconcilable definition of E&I is why in 2017, respondent sent a self-serving letter to the appellant updating Schedule E to match the words in Section 109. This is an open admission by the respondents that Schedule E is part of the four corners of the agreement, that the definition in Section 109 and its corresponding calculation were at odds. And while the court did not acknowledge this obvious inconsistency, respondent did in writing and took the incredible step to amend the agreement unilaterally in its favor.
How do you answer your friend's point that to give effect to your interpretation would lead to a commercially unreasonable result of a withdrawn partner receiving a bigger disbursement than the active partners?
Well, first of all, I think that we need to address the fact that there's an ambiguity in this case, which would lead us to go to trial and where we would exactly address those issues. But it's not uncommercially unreasonable to accept the appellant's explanation for what happened in this matter, because if my appellant signed an agreement in 2015, which he relied on for future payments in the next 5 years, and then they could unilaterally just change that at any time, then how is that agreement, retroactively, how is that agreement valid in any way? They could actually continue to change the income hurdle rate and the operating expenses, which they weren't supposed to double dip because of the gaming issues. That's the reason why we're in this matter here today.
Does it, and I know that this is, it's another issue. Does it matter that in the agreement that the defendants were permitted to update the income hurdle rate from time to time in their sole discretion?
Well, if you look
as opposed to amend it.
Okay,
they were allowed to update it.
Well, first of all, if you look at Section 905 in the agreement, it does not say the word withdrawn member at all. As a matter of fact, the statement is void of any language that applies to the ability of a current member to modify a prior executed agreement with the withdrawn member. It would make the agreement nonsensical. How would a withdrawn partner is leaving a company, he signs an agreement, he relies on that agreement for the payments going forward, and then at any time they can materially change the income hurdle rate and add customary operating expenses, which was not the true intent of the agreement here.
But could they change the income hurdle rate?
Excuse me, Your Honor?
Could they change the income hurdle rate without his consent?
The income hurdle rate is the intention of the parties when they signed this agreement was the income hurdle rate was a fixed proxy in lieu of operating expenses. The income hurdle rate was already cushioned with to include operating expenses. So this way they couldn't double dip, and then the appellant would rely on his agreement in 2015.
Okay, thank you.
Oh, can I continue?
Your time is up.
Oh, okay.
All right, you didn't see the light go off, huh? You'll have some time on rebuttal. And we do have your papers in the record, in the briefs.
Good afternoon, Your Honors. Deanna Davidian of Arkansas Bakken for defendants respondents. The Supreme Court correctly dismissed the complaint because plaintiff was paid in accordance with the clear and unambiguous terms of the agreements. There's no dispute that Addendum B, Section 1.04b2, sets forth the formula for calculating withdrawal payments, with the excess net income component of this formula expressly defined in Section 1.09a. There's also no dispute that plaintiff was paid over $2.3 million in accordance with these provisions. The Supreme Court properly rejected plaintiff's interpretation of the definition of excess net income because it is inconsistent with the plain language of the parties' contract.
What if you make of the spreadsheet?
Your Honor, the spreadsheet doesn't create any ambiguity, and the Supreme Court correctly found that to be the case. And the reason why is because there's no dispute here that excess net income, the excess net income component is expressly defined in Section 1.09a, which is clear, unambiguous, and makes no reference whatsoever to Schedule E. Schedule E is merely a sample calculation for illustration purposes only.
But the calculation is different than the formula.
I think it's somewhat unclear. It's a very convoluted spreadsheet, and the spreadsheet provides that excess net income is total revenue minus income hurdle rate. Total revenue is not a defined term. It's not defined
So
anywhere.
isn't that, I mean, just by your own statement right there, I think it's somewhat unclear, right? This is a before I've produced any discovery, before we have any depositions, you yourself have just said, I think it's somewhat unclear. Why not let everybody, and clearly there is a dispute over which view of the payout should prevail. Yours is the one from the document. Counsel for the plaintiffs is the sort of the appendix or the exhibit or whatever, which actually is supposed to play out how it would work out. I mean, you yourself have to acknowledge that later on you sought to amend the agreement to fix that, correct?
Your Honor, just to clarify my earlier statement.
I don't want you to clarify that. I just want you to ask me, did the remaining partners themselves try and fix that later by amending the agreement?
Schedule E was amended in 2017.
I mean, obviously, if there was no ambiguity, there would be no reason to amend it, correct?
The reason it was amended is because plaintiff was pointing to Schedule E as a basis to support his interpretation of the agreement.
And if you didn't think there was any problem, why bother amending it?
Well, the fact that it was amended only helps us, but I don't even think we get there because it's the fact that it was amended. We don't even get there. I don't even think you need to get to Schedule E here because the definition is expressly defined in Section 1.09.
But that appendix that shows how it's supposed to be executed is part of the agreement too, right?
Schedule E is part of the agreement.
And that doesn't, and the way that Schedule E works isn't the way that the defined term or the formula in the agreement works. I mean, do we agree on that? Let's start with that. One has.
I think Schedule E, for the reasons I previously stated, is within itself is a convoluted spreadsheet that plaintiff himself drafted. I think it's unclear because it uses the term total revenue, which is not a defined term. It's unclear whether expenses are deducted within total revenue. But leaving that aside, we don't even get to the spreadsheet because the definition of excess net income is expressly defined in 1.09a. So, and 1.09a is clear and unambiguous and itself does not reference Schedule E. So if hypothetically Section 1.09a was ambiguous, you may look to other parts of the agreement, including but not limited to.
No, that's not right. If two different parts of the agreement disagree with each other, that automatically creates an ambiguity. You can't say one's unambiguous and because of that, the other part of the agreement that creates the ambiguity should be ignored. That would, essentially what you're saying to us is only pay attention to the part that I think is unambiguous and ignore the other part of the agreement, which is part of the agreement, we just agreed on that, which creates the ambiguity. And that's not what the law says, right?
Well, the issue is just how do we define excess net income? And our position is that it is defined in 1.09a, and 1.09a is clear and unambiguous. But, Your Honor, even if this court finds that Schedule E creates an ambiguity here, and we submit it does not, but there is no dispute here that Schedule E was properly amended in 2017. Therefore, any ambiguity argument would apply solely with respect to the withdrawal payment for 2016.
I mean, but that doesn't go to a pre-answer motion to dismiss, right? This is a pre-answer motion to dismiss.
It does, Your Honor, because in that case, plaintiffs' claims with respect to withdrawal payments for 2017 through 2020 were properly dismissed because of the amendment. And plaintiff conceded that below during oral argument. It's pages 14 and 15 of the record, as well as page 352 of the record, and the affirmation of plaintiff's attorney, they conceded that that corrected any alleged ambiguity. Again, we submit there is no ambiguity here. Your Honor, I see my time is up. If there are no further questions.
Oh, we do. We have a question.
Well, I wanted to know, can you amend the agreement without the plaintiff's consent in accordance with clauses 9.5, 1.02, and 1.10?
Your Honor, the agreement can be amended. It expressly provides that a majority in interest can amend the agreement at any time. Therefore, during plaintiff's tenure at the company, they didn't need his consent to amend the agreement, and after he withdrew, they also didn't need his consent to amend the agreement. There are only 2 limitations on defendant's ability to amend the agreement, and neither one of them applies here. And I'm happy to go through them, although I want to be respectful of my time, but I'm happy to go through them if that would be helpful to the court.
One further question.
Tacking on to Justice Scarpulla's point, we have to read this agreement as a whole, right, and give effect to all of its parts.
Correct, Your Honor.
It seemed to me that you would win as a matter of law if one word had been added to the top of the spreadsheet, and that is the word that you used in your brief and that you used here this afternoon, the word only, because the word illustration appears at the top of the spreadsheet, but that word only is not in the document itself. And if the parties wanted to make it clear that this was just for illustrative purposes and solely for illustrative purposes, they could have made that point express.
The agreement provides it's a sample calculation. Again, it illustrates how to multiply various factors. It doesn't define any of them. And it does say it is for illustration purposes. Again, just in sum, there's no dispute here that plaintiff was paid in accordance with the contract. Plaintiff is asking this court to rewrite the contract. And
We understand your argument.
thank you. Thank you, Your Honor.
Your Honors, Addendum B is the only section of the agreement that deals with the treatment of a withdrawn partner and where the excess net income is defined. Each schedule, there are 5 schedules in Addendum B, and each schedule is referenced and labeled. Schedule A to Addendum B, Schedule E to Addendum B, and so forth. In fact, Schedule C refers to Schedule E for information. Section 109 of the Amendment B states, the following terms as used in Addendum B shall have the following meanings, unless otherwise expressly provided herein. Calculation in Schedule E is the unless expressly provided herein, which provides the correct definition of excess net income in words and in numbers. If you read this schedule, you know what the definition of excess net income is. And it clearly is ambiguous with Section 109, where the definition of E&I is defined. And therefore, this court should reverse the lower court's decision and go to the trial on the merits to determine the intent of the parties with respect to the definition of excess net income and the calculation for a drawn member's payout.
Okay.
What about the update to the income hurdle?
I'm sorry, Your Honor, I couldn't hear
The
you.
update, that they updated from 1.5 to 2.2.
So, Your Honor, the income hurdle rate is a fixed proxy, and that was the intent of the parties. It was fixed at 1.5 million. In a company such as APIS, there's very low overhead. It's five employees and a coffee pot. So basically, what they do is to allow the withdrawn partner to rely on the agreement he signs in 2015. They fix the income hurdle rate. So this way, he knows exactly the payments he's going to be receiving in the next 5 years. If you look at section, like I said, 905, there is nothing in that section that talks about a withdrawn member. It only talks about current members or future members if they should want to change the income hurdle rate going forward. How can anyone sign a contract in 2015 and rely on that contract if it can be changed?
Okay, thank you.
Thank you, Your Honor.
Thank you both. The next case for argument is Bat Brothers versus Palshuk.
Good afternoon, Your Honors. May it please the Court. My name is Kevin Murphy. I'll be arguing on behalf of Appellant Sergei Palshuk. There were three key averments that were made by Bat Brothers LLC that led the Court to grant summary judgment in its favor. The first averment was that Bat Brothers was an arm's-length debt collector. Number two, that Bat Brothers was collecting a debt from GEM, Golden East Mongolia. Number three, Palshuk was responsible for that debt because GEM wasn't paying it. None of those things turned out to be true. Mr. Palshuk, a year after summary judgment was granted against him, found out through an insider, the former legal counsel and deputy director of GEM, that in fact Bat Brothers was a creature of GEM, solely directed by GEM, and that GEM essentially was purchasing its own debt in order to double collect from Mr.
Was this
Palshuk.
any different than the arguments that you made in the prior appeal when the court affirmed the entry or the domestication of the Russian judgment?
It is very different, Your Honor, and
Why?
from different sources. I know that Your Honor was present on the panel
Present,
previously.
meaning I was part right.
Yes.
You are right. Not my
The
first
key-
time on this.
The key issue, Judge Gish, is that you can take a look at 541 of the record. 541 is the appellate division result from the preceding appeal. That appeal concerned the merits of whether or not we could make a counterclaim in the action. That was
That was
down.
part of it, but part of it also was to the extent that you were trying to attack the underlying judgment from Russia. We said that the comedy that we give to it is more ministerial. We don't kind of dig under to the propriety of the arguments that were decided against you in the Russian court. Didn't we say that?
The specific language is important, Your Honor, because it's truncated and selectively quoted by the Supreme Court as a result of the briefs of Bat Brothers. Quote, defendants' arguments that the debt underlying the Russian judgment has been paid or otherwise terminated by operation of Russian law are misplaced in this Article 53 proceeding because they go to the merits of the underlying judgment. The key distinction, Your Honors, is that this was a counterclaim brought under Russian law, and it was inappropriate according to this court. This is not about whether or not there was debt on which there is collection. That is not an issue of Russian law, and it goes directly to Article 5304B4, which concerns whether or not a recognition of the foreign judgment will be repugnant to the public policy of this state. It is the public policy of this state that double collection of a debt is repugnant to the public policy of the state and should not stand. And so, therefore, this is absolutely what is allowed under the law, and it was the Supreme Court's truncation of the language to something different. And you'll find this on page 6 of the opinion. Moreover, as the appellate division recognized in its decision and order, arguments as to the merits of the underlying judgment are misplaced in an Article 53 proceeding. That cannot be the law because it violates the statute itself, which allows for an argument as to it being repugnant to the public policy of the state.
Position that, for example, if the state of Texas has a law that isn't in the state of New York, that we cannot domesticate a Texan judgment because it would be repugnant to the law of the state of New York?
No, I was simply answering Judge Gish's question concerning...
You just said that this is the double collection is repugnant to New York law?
It is
repugnant. We can't domesticate the judgment?
It is repugnant to the public policy of New York State if it's double collection. There is no state in the union.
I'm going to ask you if there is a Texas judgment based on a Texas statute or a Texas common law that is different, and there are many that are, particularly in the areas of like labor and employment, that we should not domesticate because it's different than our public policy?
A Supreme Court has the right to say no as repugnant to the public policy of the state.
We could say no to a Texas judgment on a labor and employment case because their labor and employment law is different from ours?
The argument could be made, is all I'm saying.
Got it.
Is all I'm saying. It is.
You're arguing under Article 53, not under Article 54. Right?
Correct.
This is recognition of a foreign judgment.
Correct.
Not domestication of a sister state or federal court.
Yes, thank you very much. Yes, that's exactly right. They're very different statutes, absolutely. And so the argument, Judge Scarpullo, would be that it would be something from Britain, for example, or something from...
Exactly, or Australia, who have different employment laws and in different, I mean, that are not ours. They are different. And you're saying for that reason that we should not domesticate those judgments?
I'm saying that it's an option. But here, in this case, this is about double collection of a debt that is repugnant to the public policy of all the 50 states, as well as all the Western world.
We already affirmed the recognition of the foreign judgment, and you did, in that prior appeal, argue that it was a double collection. And we said it seems like it's a valid judgment under Russian law, and therefore that we're going to exercise it. So now you're coming back with something you say is different. Quite frankly, I'm not sure it is, but you do make those arguments, and I think we understand them. But let's hear an argument from your adversary.
Understood, Your Honor. Thank you.
May it please the court, my name is Mitchell Geller of Holland & Knight LLP, and we represent the plaintiff respondent. So I first want to point out, since I was the one who argued the last appeal before this court, I am actually shocked, because when I was listening to his argument, it was as if he was arguing the exact same thing as he did before, and we are well beyond that.
Well, he actually brings up some new points regarding something that happened in 2020 that is confirmatory of his claim that the Russian judgment is invalid, right?
No, he doesn't bring that up at all. What he says is number one, by the way, he argued before, when we were here the last time, that there was no debt owed by GEM. That was one of his principal arguments.
Yes, it was.
He had many other arguments, but his principal argument was no debt was owed, and there would be a double collection, and it would be repugnant to the policy of New York State if you somehow enforced the Russian judgment. That was totally untrue, because there was no double collection, because we specifically showed that the debt had not been paid. So even apart from the limitations on Article 53, all of his arguments had been rejected factually as well as legally. But the fact is, he actually, in the oral argument in 2018, before Justice Barak, Mr. Murphy, Pauschik's attorney, stated that the debt was eliminated, and, quote, what we have shown in the financial records of GEM is that GEM has no debt as of today. That's record 34. He also argued many other things, like Bat Brothers was an empty shell. Again, he argues this in his papers. He argues, in fact, the exact same arguments, and that is why Justice Barak, who had heard the prior motion for summary judgment, specifically said, Pauschik's motion to vacate must be denied as an attempt to rehash many of the arguments already advanced to this court and to the appellate division, each of which was considered and rejected, record 8. Now, I would like to point out that specifically, number one, we all know what this motion is about has nothing to do with Article 53 or about double collection or about what is repugnant to the state of New York. It has to do with one thing only. There was a New York judgment that enforced a Russian judgment under Article 53. This court affirmed that judgment. He then sought leave to appeal to the Court of Appeal. That was rejected. So now he comes back about 3 years later, and he says,
I want to vacate that judgment for fraud under 5015A3. What's amazing to me is he didn't even address that. We all know under 5015A3 that granting a motion under that statute is extremely rare. And why is it rare? Because of the standard, the clear and convincing standard, and the heavy burden that the defendant faces on such a motion. And the only time it happens generally is when you have a plaintiff who literally swore at trial about something, and it's one of the cases he cites called Pizzi, P-I-Z-Z-I, where the party actually had post-trial admissions that were contrary to his prior testimony. That's the only time, generally, when you vacate a judgment for fraud. But I have to bring up one thing which is really very, very alarming. And there are two statements in his reply brief that are false and directly contrary to the affidavit of a gentleman that he says was an employee of Bat Brothers, which is untrue. Bat Brothers is my client. In his brief at page 1 of his reply brief, he says, Mr. Pauschik learned the truth of these misrepresentations and fraudulent documents from an insider at Bat Brothers, Niamson Tosagatel, who served as legal counsel and deputy director of Bat Brothers. And then on page 2 of his brief, he says, Bat Brothers, for example, does not dispute that Mr. Tosagatel was in fact the legal counsel, then the deputy director of Bat Brothers. That are false statements. It is undisputed. Mr. Tosagatel's, excuse me, I can't pronounce this, so I'm going to call him Mr. T. His two affidavits specifically state that he is employed at Alton Dornad Mogul, formerly known as Golden East Mongolia Gem, and Gem is the one who owes the debt. He, Pauschik, was the guarantor of that debt. That's why you had the Russian judgment and then the New York judgment. The fact is, his own brief on page 10 states that Mr. T is, quote, a former legal director of Gem. So he's not an officer of Bat Brothers, and to actually state in his reply brief that he is an officer of Bat Brothers when he is not, could only be done for one purpose only, to somehow lend credibility to his argument when there is no fraud, misrepresentation, or misconduct.
All right, thank you. Rebuttal?
With respect to the different arguments, it was an argument, there was some overlap in the argument because it was based on an analysis of GEM's financial records. It was not based on the government of Mongolia doing a criminal investigation of Bat Brothers and GEM and determining that there was no debt. These are extremely different circumstances. One circumstance is looking at it from afar and saying, I don't think there should be summary judgment on this, and the other one is that the government has come forward and made a fundamental observation that there's no debt of Bat Brothers there's no debt that's owed to Bat Brothers by GEM in the books of GEM, in the books of Bat Brothers, which means that the debt reconciliations are fraudulent documents, and the court should enforce that. With respect to this notion that I somehow misstated who's who, that's possible. I looked at page 10 and I don't see it anywhere. Ultimately, the issue is that these material facts are in dispute. There at least should be an evidentiary hearing. Mr. Pauschik should have his day in court. He should not be the subject of double collection.
Okay, thank you.
Thank you, Your
Thank you both. $850 Third Avenue versus Discovery.
Good afternoon, may it please the court. Josh Wartzel from Schlom, Stone, and Dolan for the plaintiff, appellant, and the property owner here. Your Honors, this is a straightforward rent collection case brought by my client, the property owner, against the company that owns the Discovery Channel. There are two fundamental questions to be answered on this appeal, and they both can be answered by looking at the lease agreement itself. The first question is whether the tenant, the Discovery Channel, or Discovery Communications, was permitted to remain in the property, in the space, after the end of the lease without paying any rent. And the second question is, was the tenant, if the tenant was not permitted to remain in the space without paying rent, what was the rate at which the tenant was required to pay rent? So, Your Honors, in response to the first question, the lease controls here. The lease says that you must quit and surrender and remove your property on the termination date. The termination date being the last day of May in 2020. It is undisputed that Discovery, the tenant, did not do that. In fact, Discovery admits that they didn't start removing their property until, I believe, the end of June. They didn't finish removing it until one of the last days of July. And they also admit that they continued to access the property throughout that entire time. They say for essential purposes. They admit it was for mail, it was for security, it was for IT. They hadn't handed over the keys. They were still using the property. They were still in possession of this property.
You know, I don't know that the facts are necessarily in dispute in this action. As I understand it, the application of certain lease provisions may otherwise be disputed because there is at least a provision of the lease, I think it's 2603, which deals with the extension of time periods. And this is one of those cases where in the context of the pandemic and executive orders by the governor that allowed and prohibited certain business operations and/or possibly force majeure may have applied to otherwise extend that period by which the tenant had to be out at the end, at the termination date of the lease. Go.
That's correct, Your Honor. And I agree they're not factual issues here. And that's one of the reasons why this case can be decided on the law by this court. And it was error by the motion court to deny summary judgment. One way or another, a party should win based on the lease.
Well, that's not exactly true either, because within the context of the provisions are factual scenarios that would otherwise allow for the extension of the termination date or not. And those facts are very much disputed. What's not disputed is that after the date that you mentioned, that Discovery had not left the premises. That's not disputed.
I agree with that, Your Honor. So on the force majeure point, Your Honor referenced 2603 of the lease. This is record page 119. So what that clause says is when a period of time is prescribed for the taking of an action by landlord or tenant other than the payment of the security deposit or rent, the period of time for the performance shall be extended by the number of days that the performance is actually delayed due to strikes, acts of God, shortages of labor or materials, war, terrorist acts, civil disturbances, and other causes beyond the reasonable control of the performing party. Conspicuously absent from that force majeure clause, yet included in many other commercial leases force majeure clauses, is either pandemics or specifically here, governmental orders and regulations. Specifically...
Well, so, but it does say and it has that big old catch-all phrase, right? So you can't get away from that catch-all phrase. And anything else that's outside of the party's control. And clearly a government shutdown because of COVID is outside the party's control. So there is an argument to be made that that's covered from the force majeure clause, and I think the Second Circuit has just said that, right?
So I disagree. Well, first of all, I agree there's an argument to be made. That's what Discovery is arguing.
And don't you think the Second Circuit has just said that?
I disagree with that. So in the Second Circuit, the JN Contemporary case that's cited here, the district court case is cited here, the force majeure clause there was very different. The force majeure clause there said your performance is excused, or our performance is excused, if any act outside of our control takes place, including without limitation the following things. So the operative portion of the clause says...
we can quibble back and forth, but the fact of the matter is that at least one court has held that the COVID-19 pandemic kicked in the force majeure clause, right? And this is a motion for judgment without discovery, without anything else. And not only are you not seeking the rent, you are seeking holdover rent, correct? Which is different because the way I read the record, the tenant offered you plain rent, and you said no. You wanted holdover rent, correct?
If I may just respond briefly, Your Honor. So that's incorrect. We are seeking holdover use and occupancy.
Which is completely different from straight up rent, and it's not, and so there's an issue of fact there as to what rent is due. If the force majeure clause would mean that only rent is due or holdover rent is due, because that would make a difference. I think it would make a difference of like 200 or 300,000 a month, right?
That's correct on the numbers, and Your Honor, I disagree there's a factual issue, but just on the factual point that Your Honor mentioned, I just want to correct something. The tenant in this case is arguing that they are not responsible for paying any rent. They paid 1 month, which they claim was an error. They demanded it back. They're suing us. They've counterclaimed against the owner, seeking it back. So they have not conceded that.
No, I agree. Why should they, right? But you're saying, not only do I want a rent, I want holdover rent. You're not seeking regular rent.
Well,
You're seeking holdover rent.
we're seeking
which is 1.5 of a very big number, correct?
Correct, Your Honor.
So, if the force majeure clause applied, that would, at a minimum, change the calculation.
Your Honor, respectfully, I disagree. And if I may answer just very briefly.
You may answer that question.
Thank you, Your Honor. So if even if the force majeure clause applies here, and for the reasons in our brief, we argue that it doesn't, but even if the force majeure clause applies, the force majeure clause carves out from its application the payment of rent. And the payment of rent and additional rent, rent is included, the definition of rent includes additional rent. Additional rent means anything else that's due under the lease. So whether you call it holdover use and occupancy, holdover rent, base rent, paying for the elevator, all of that fits into the category of rent. The force majeure clause, even if it applies, does not excuse the payment of rent. Thank you.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court, Mitchell Haddad for the respondent discovery. The lower court properly denied appellant's pre-discovery motion for summary judgment and to dismiss respondent's counterclaims after finding that there were substantial issues of fact in dispute, including whether the respondent could and did utilize the premises after its lease expired. Discovery quit the premises in March of 2020, 2.5 months before at lease expired, but paid the rent to the end. Appellant asserts that respondent is a holdover because it left its property in the premise, not because it had its 600 employees there. The appellant alleges that 4 or 5 employees came in a few times to do security and check mail, and that constitutes using the premises, as if a store continued in business or a company continued to operate its business. That's not what happened
Could they
here.
have relet the premises? Could they have relet the premises while you had your stuff there and people were coming in to pick up mail and do other things?
Well, that's a good question, because in order to be a holdover for leaving property in the premises, the landlord was required to prove that appellant left the property in the premises with the intent to continue its tenancy. Intent is an issue of fact. There's no evidence in this record. Number 2, the appellant was required to prove the type, the quantity, and the extent.
I know, but was there really an issue about the quantity of what was left there? I mean, a lot of the dispute that was not worked out amicably had to do with the fact that you couldn't get movers in to take stuff out. If it was so minimal as you suggest, why did you need movers?
The issue, Your Honor, is that there has to be evidence in the record to determine whether or not the leaving of property makes the person responsible for, as a holdover, and then obviously they're trying to get the holdover rent.
I'm aware of what the standard is.
But
I am somewhat, I'm just questioning whether there really are disputed facts here or not.
Well, I think there are, Your Honor, because they're alleging that Discovery continued to maintain and do business as usual, and Discovery has clearly disputed that. They're alleging that we left property in the premises, but they don't say what type of property. They don't say, as they're required to.
Counsel, let me
law.
just ask you this. So your point is, if I left property there under the lease, you could have packed it up and shipped it out and charged me for it, rather than charging me 1.5 point times the rent as a holdover tenant. That's your point?
Well, one of the points is correct. Section 25 of the lease provides that if property is left in the premises, the tenant has 5 days within which to remove it. And after those 5 days, landlord can either give notice to the tenant and put it in storage and charge the tenant, or after 30 days, landlord could take title to it.
But if you're a holdover, you have to pay 1.5 times the rent.
No,
right? So-
because there's nothing in Section 25 which provides that you're liable for holdover rent.
So you're assuming that we don't find your holdover. I don't know whether or not we're going to find that. I mean, the lower court said he does. He didn't know on this record.
I think Your Honor hit the nail on the head earlier when you were talking about the extension of time to remove property and the force majeure event. There is an enumerated event here, and the enumerated event is a labor shortage. The lower court properly found whether commercial movers were prevented from operating during this time period is an issue of fact.
Which is actually a separate provision than the force majeure. It's a separate condition under 23. It's a shortage of labor, but here, quite frankly, we're talking about the absence of labor, right?
I think they're synonymous, and there's no evidence in the record.
You think that force majeure and the labor problem are synonymous?
Yeah, because the labor shortage, the labor issue, is a defined event of force majeure. But there is another provision, and that is the provision, other causes beyond the reasonable control of the parties. And the Second Circuit did come down, and they specifically said, the pandemic and government shutdown orders are the same type of events listed in that case as force majeure clause, which included terrorist acts and war, which are in our force majeure clause, because the enumerated events are a type that cause a large-scale societal disruption, are beyond the party's control, and are not due to the party's fault or negligence. If you look at the Kel Kim case, the Kel Kim case concerned a tenant who couldn't get insurance. And the Court of Appeals stated that was not a social and economic disruption that interfered or prevented the party's day-to-day business operations. To the contrary, the Second Circuit has just squarely held that I suggest it's instructive, is that where you do have a societal social disruption, and businesses are really, everything just stopped. We have to put this case in the context of what had happened. This was the height of the pandemic. Everything was shut down. The city was a ghost town. The courts were down. Hospitals were overfilled. That disrupted the day-to-day operations of everybody's business. And as the Second Circuit said, and as even Kel Kim says, then you have to look at, that falls within what you would call the catch-all, and that has to be the main focus, Your Honors, of that analysis, if in fact, I think you don't have to get there. I think there are so many other issues of fact that you don't have to rule on force majeure at this point in time because of the absence of sufficient facts in this record. But I do believe that enough has been stated in opposition to show that there are material issues of fact and that the lower court correctly determined that, they accepted rent.
We understand.
At a minimum,
we understand.
We are, as I said,
Thank you.
month to month. Thank you.
Yeah. Rebuttal, sir.
Returning to Justice Scarpulla's question about, are there issues of fact as between base rent and the holdover rent? I'd like to go back to, does the catch-all of the force majeure clause apply? I submit that the clause in the JN Contemporary case that the Second Circuit just decided was different than the clause here. But I'd like to refer the court both to Kel Kim as well as the team marketing case and the forward industrial case on page 20 of our opening brief. These are appellate division cases holding that when you have a catch-all clause at the end of a force majeure clause, the catch-all clause only picks up things that are similar in nature, of like kind, to the things that are specifically enumerated. And Kel Kim says that we have to interpret force majeure clauses narrowly. So the parties had the opportunity here to include government regulations in the force majeure clause. The fact that they didn't, and included only things that are, things like war, labor shortage, strikes, terrorism, right? Those are things that are in a very different category than a government order. In particular, as well, my adversary made the argument that, well, I'm not sure I quite heard an answer whether whether the owner could have relet the space. Not only did they have a few items left, they admit that they were continuing to occupy the space. They admit that they were continuing to use the space. They were continuing to go there for mail, for IT, and so on.
Wait, what do you mean they admit? Is there an answer to this complaint?
Your Honor, so there is an answer. They have said in their papers that
Well, you filed an answer after your motion to dismiss was denied, right? Or
so what they admit is that they continued to access the space for IT. They continue to access the space for essential purposes. They say that. That's in their brief. That's in their that's an admission that they have made. So there's no dispute that they were continuing to come and go. They say, well, it wasn't 600 employees. Maybe it was only 10 employees or 15 employees. But we couldn't retake the property and relet it to somebody else.
Well, an admission that they had some access to the property it isn't the same as an admission that they had the ability to move the remaining wares out of the leasehold.
Your Honor, if I may just briefly answer, there are two different issues. The issue that Your Honor is raising is whether they had the ability to move out and move their items, right? And they're saying, well, we didn't have the ability, and the force majeure clause excuses our non-performance and allows us not to pay rent or holdover use and occupancy. But what I'm saying is slightly different. What I'm saying is that their claim that they had surrendered the property, that they had quit and surrendered the property months earlier, cannot be squared, is inconsistent with their own admission that they continued to access the property. So there are two different things. One is whether the force majeure clause excuses their performance or whether they could perform in the first place. But the second, and the point that I was making, is just that they had not yet quit and surrendered the property, and thus it triggers the holdover clause.
Okay, thank you. Thank you both. People versus Patterson. You may proceed.
Thank you, Your Honors. Good afternoon. Molly Schindler on behalf of Philip Patterson. May it please the Court. The SORA Court's upward departure from the risk assessment instrument results in this case not only overassessed Mr. Patterson's current risk, but it actually had the counterproductive effect of destabilizing him by removing him from access to supportive housing that would have increased his stability in the community and provided a smoother transition onto his 10 years of intensive parole supervision. Instead, the level 3 order by upward departure forced him to live alone in the chaotic environment of Ward's Island. This was both legal error and an abuse of discretion because the prosecution failed to identify any valid aggravating factors to provide a basis for upward departure that were not in any event outweighed by the mitigating information in this case. The evidence presented to the SORA Court showed that Mr. Patterson had spent the last 4 years before his guilty plea, but after the commission of the offense, addressing the issues that contributed to that offense, which was an aberration in his criminal history to begin with. He had made it to 28 years old without ever having been convicted of an act of violence or a sexual offense prior to the instant offense. During this time, he had then developed tools and coping mechanisms during his time in treatment for his developmental disability that would allow him to return to the community to continue the stability he had achieved. There were no aggravating factors that merited an upward departure because although there is no doubt this was a heinous offense, it was adequately accounted for by the risk assessment instrument's level 2 result.
Was there certain information that was not before the SORA board that ultimately was presented or available to the SORA court?
Yes, Your Honor. There was a lot of information about Mr. Patterson's time at Sunmount Developmental Center and evaluations that were done that was not before the board. That information did not, for the most part, did not pertain to the risk assessment instrument, but rather the SORA court's departure determination. However, that information included not only the period of instability that he had in 2016 and 2017 at the time of the instant offense and at the time of the evaluation that respondent focuses on in its brief, and an incident early on in his time at Sunmount. But it goes on, that information goes on to demonstrate the immense progress that he made during the 4 years he spent there, as well as his tremendous stability that he had achieved and tangible results of his hard work at Sunmount, culminating not only in his return to competency, but also his development of coping mechanisms and other ways to handle his developmental disability, as well as his history of depression, without turning to the poor mechanisms he had turned to in some instances
Counsel,
in the
do you,
past.
I'm sorry, excuse me, do you agree that he should have been assessed points under Factor 11 for alcohol and drug abuse?
Yes, Your Honor, we conceded that at the hearing.
Right, and so that would take him right at the top of level 2, correct?
Correct.
You
but
don't dispute any of that.
Not at all, Your Honor, but that level 2 result was the correct
And the one reason he got a lower number was because the sexual assault, he couldn't complete it. He couldn't get the victim's pants down. And so he got 5 points rather than 20 points or I think it was 20 points, right? So that's basically why he got a level 2 instead of a level 3, right?
Your Honor, that is not an argument that the prosecution advanced
I'm just
below.
asking you, right? Is that all factually correct?
It's factually correct that he got those 5 points.
And then in 2017, the psychologist that assessed him said, it is highly unlikely that defendant would engage in inappropriate conduct if he was highly supervised and not doing drugs and alcohol, right? So he has yet to have any evaluation that says that he could live in the community without intensive supervision, correct?
Your Honor, that is correct, but what's also important about that evaluation compared to the subsequent evaluations is that none of those evaluations, 2017 is prior to any of the treatment that he received and any of the progress that was demonstrated.
Well, in 2021, he was still found incompetent, right? So he wasn't treated well. I'm sorry, let me see, 2020, there was 2019, he wasn't found competent. So the next evaluation, he hadn't
there is no
successfully transferred to a place where he could even stand trial, right? As late as 2019.
It's correct that he was not restored to competency until 2021, but if I could respond to that point, I understand my time is up. There is no equation between being competent to stand trial and being at an increased risk of sexual recidivism. That is absolutely not supported by the evidence, and I would invite Your Honor to review those evaluations from 2017 all the way through till 2021, and the evidence from his treatment providers describing the improvement in his conduct and the stability that he achieved, and contrasting that with the person that he was during that single period of instability in 2016 to 2017. Thank you.
Thank you.
May it please the court, Diana Lewis for the respondent, the Bronx District Attorney's Office. Your Honor, you are correct. SORA is meant to assess a defendant's risk once they are released into the community. People can see the defendant did make progress while he was confined, but that's not the purpose of SORA. We've seen what this defendant is capable of, and unless Your Honors have any questions for me, I will yield my time.
Any questions? Thank you.
Your Honor, Mr. Patterson's due process rights and the Court of Appeals precedent requires a valid basis for an upward departure that the prosecution did not establish here in any of the steps of the Gelati analysis. There was no identified basis, there was no identified factor that was both proven by clear and convincing evidence and shown to elevate his current risk of sexual recidivism, nor finally that was not outweighed by the mitigating information, in particular what transpired between the years of 2017 and 2021, the time of this SOAR hearing.
Let's assume that steps 1 and 2 of Gelati were satisfied. Now we're in the balancing stage. To your friend's point about the heinousness of this offense, and Judge Scarpulla's earlier point that perhaps he was spared some points because he wasn't able to complete the sexual act, how do you satisfy step 3 of Gelati?
By all of the information about what happened since 2017 to 2021, which is not adequately accounted for in the risk assessment instrument because, as my opponent pointed out, it was not before the board and it is not found in the instrument. That progress that he made, as well as the fact that the level 3 result has this counterproductive effect that is not going to serve the community and is not serving the community by preventing him from accessing supportive housing. That is the direct impact of the court's upward departure to level 3. And that is absolutely an aspect of the totality of the circumstances under the third Gelati step for this court to consider, coupled with the heinousness of the offense, which is always a factor in a SORA case. However, I would submit that all of the evidence together demonstrates that Mr. Patterson is not only appropriately assessed at level 2, but level 2 would serve the community the best and maintain his stability. Thank you.
Thank you. Thank you both. The next case for argument is Simo versus the City of New York.
Good afternoon, Your Honors. May it please the Court. Diana Lawless for the appellants, the City and the Parks Department. The defendants are entitled to summary judgment here because an inherently dangerous condition did not cause the plaintiff's fall. The defendants established prima facie that the steps that the plaintiffs alleges caused his fall were not inherently dangerous and they did not conceal any hazards. The evidence showed by the plaintiff's testimony in the photographs is that the plaintiff fell when he made a misstep on stairs that weren't defective. He never said anything that suggested a defect in these steps. He said that he fell when he stepped into the gap between 2 steps. The steps were there was dirt that separated the concrete risers that compromised the boat launch point. There's nothing defective about including dirt between concrete risers of a boat and ramp, and the depth and the gap between the steps are an inherent feature of the steps that were readily apparent to him. He didn't miss the step due to being unaware of its existence or fall as a result of any type of defect. He also was distracted, but while he was looking at his phone. So here we believe that we were entitled to summary judgment on this basis because there was no inherent danger, and the court didn't have to focus on the lack of actual and constructive notice. We didn't have to establish that because there was no identified defect that needed correcting, and then the court did not need to look into the significance of the lack of a warning sign, handrail, or barricade. Because it was open and obvious, there was no duty to warn, so no handrail or barricade was needed, and the plaintiff's testimony, the lack of a handrail, was totally speculative here. If Your Honors have no further questions, I'll yield my time to my adversary.
Thank you.
May I proceed?
You may.
Good afternoon, Your Honors. Daniel Wright from Burns & Harris for the plaintiff respondent. Your Honor, it was the city's burden to establish that they had not caused or created this defective condition or that they did not have notice, either actual or constructive, of this defective condition. The city completely failed to address whether they had caused or created this defective condition. So on that ground alone, their motion to dismiss is defective and fatally flawed.
Well, but they're raising a separate, distinct defense, which is the open and obvious doctrine. So even assuming there were tribal issues of fact as to whether they caused or created, they're saying we're entitled to judgment a matter of law on this separate, independent defense.
Correct, Your Honor. As for whether it's open and obvious, I believe the Supreme Court was correct in saying that that's not fatal to the negligence claim, whether this defect is open and obvious or not. That would go to an issue of having a duty to warn, or whether it would go to an issue of comparative fault, whether it's open and
The issue
obvious.
of whether it's inherently dangerous, that is fatal. If it's inherent, right? If it's
Right.
not inherently dangerous, you have no claim here.
Correct, that is the main issue. And in support that this is an inherently dangerous defective condition, we provided the affidavit of Dr. Marletta, who is plaintiff's expert, who has expertise in walkways, specifically stairs, ramps, flooring, who went physically measured this site where the plaintiff fell, researched the applicable codes, the statutes, took photographs, and he found that this is an inherently dangerous condition, in contrast to what the city did, where they're only relying on testimony and photographs, and they're looking at the photographs, making speculative, unqualified judgments that, based on the photographs, this is ordinary stairs, and there's nothing defective based on these photographs. That's what they're submitting, in contrast to an expert report who's saying his physical measurements being at the site and research of the codes that this is an inherently dangerous condition. As for constructive notice argument, they failed on their burden to prove that they didn't have constructive notice. They're relying on the testimony of Mr. Bowman, who, in his testimony, he said that he was unable to testify to the last time the steps were inspected prior to the accident. He stated that this boat ramp was not even on his field inspection form, that he would not check the boat ramp when he made his inspections at this park, that he wouldn't be looking for structural issues, dangerous conditions, and the gaps between the steps. In fact, he said it wasn't even his call to determine if the ramp was in a safe condition. So Mr. Bowman's testimony that they're relying on to prove that they lacked constructive notice of this defective condition is completely insufficient to prove that they lacked constructive notice. So if there's no further questions, I believe that they have not met their prima facie burden on summary judgment, and I'll rest on my brief.
Thank you.
Thank you.
Buttle?
Thank you, Your Honors. I just have a couple of quick points. First, I kind of just want to, as Your Honors were talking about it, just kind of clarify the doctrines here. Judge Gish got it totally right that the only thing that matters is whether it's an inherently dangerous condition. A concealed hazard is kind of like a separate sub-issue within that. So there's a world in which you can have an obvious hazard that is also inherently dangerous. But the concealed hazard only requires the duty to warn. So here we're saying we don't even have to think about that at all because there's no inherently dangerous condition. And the only thing I heard...
But based on what? What did you rely on for your prima facie case that this isn't inherently dangerous?
The plaintiff's...
photograph doesn't look so great, right?
Well, the photographs don't look great, but the place where he circled where he fell, I mean, it was stairs, and he saw them when he was walking down them. He doesn't, so...
Yeah, but you already said that seeing them is not enough. If it's inherently dangerous, then he may have a claim. What's not inherently dangerous about these steps that look uneven? The concrete has gaps in it where there seems to be earth from below and grass that's growing out of it.
Well, I think that the last part is not accurate, but how he testified, he said he fell when he stepped into the gap between two steps. He didn't say anything about the patches of dirt, the patches of grass or anything. He didn't make any connection about that. If you read his testimony, it's like, oh, I was just walking down some stairs, and then between the 6th and 7th step, I got caught in the gap and I fell. He didn't make any specific attribution about like what
Well,
could have
what's
possibly...
the gap, if not?
I personally think it's just like the stairs. We cited one case in our brief that said that when you get your heel caught on the stairs, that's not enough. Like you can get caught on things on stairs as you're walking down them.
Yeah, but he talked about a gap. What do you think that means?
I thought it was the space between the 6th and 7th step. So they're also not right on top of each other, right? So they're kind of spaced in between. So there's kind of ground and then a concrete step and then ground and then a concrete step. So I don't think he said, and when he circled it, he didn't circle anything that looked like there was anything specifically wrong with that made it look different from anything else that was there, that was not, he could not reasonably see as he was going down them, that would pose an inherent risk. And I think just to make a point about what his expert said, his expert cited inapplicable standards for maintenance, and he did not raise a triable issue of fact because he cited no standards that would apply to these steps at issue.
Nor did you.
Did you put in an affidavit from an engineer or any expert that said this isn't inherently dangerous?
We did not, but we don't think that.
So what evidence are you based on that declaration on?
The plaintiff's testimony about the mechanism of his fall and what.
Plaintiff's testimony is what you're basing your declaration that as a matter of law, these stairs aren't inherently dangerous?
Right, and I think there's other cases that are like that. If you look at the cases, particularly on stairs, I think that the records support that, the cases support that. Thank you, Your Honors.
Okay, thank you. Talos Capital versus 257 Church Holding. Okay. Right, and we're starting with Appellant Ashkenazi?
Yes, if that's okay with you, Your Honor.
Yeah, yes, I think that's
Okay.
appropriate.
Your Honor, I think it's useful to begin with the question of why this expedited procedure in CPLR 3213 exists. And the Court of Appeals answered that question in the Weissman case in 1996. Quote, its purpose was to provide quick relief on documentary claims so presumptively meritorious that a formal complaint is superfluous, and even the delay incident upon waiting for an answer and then moving for summary judgment is needless, end quote. In other words, it's for quick, simple cases. The Court of Appeals also said in Weissman, the instrument does not qualify if outside proof is needed other than simple proof of non-payment or a similar de minimis deviation from the face of the document, end quote. And this court said essentially the same thing in PDR Biopharma in 2017 and in Karen in 2002. The test is whether more than a de minimis deviation from the face of the document is needed. If it is, it's not a 3213. Your Honors, I submit that the plaintiff here doesn't come within miles of meeting that test. And indeed, I barely have time to start on going through the exercise that a court has to do to ascertain, using the words of the rule, ascertain Mr.
Well, counsel, let's assume it's not an instrument for the payment of money only, but then there's no dispute that the borrower failed to make the 5-year pay down payment, right?
I'm sorry, I'm having trouble.
I'm sorry, there's no dispute that the borrower failed to make the 5-year pay down payment, correct?
There's no dispute that...
The borrower failed to make the 5-year payment,
Yes, that's correct.
Right?
There's no dispute the borrower...
So there's $20 million is owed, by somebody at least.
Yes.
You don't dispute that.
We do not dispute that the borrower did not make the payment.
You're saying your client doesn't owe it, but you're not disputing that the borrower owes it.
Well, no, I am. That it didn't make the payment, I don't dispute. It does not. Does it owe the money in the sense it owes the money in that it is part of the loan? It is not. The money is not due and payable from the borrower. And that's critical. It is true that the loan agreement does say in that long convoluted paragraph that the borrower shall make the payment on such and such a date. But the next sentence after that says, but if it doesn't, it's not a default. Nothing happens. So there's no liability, and there's no liability for the borrower for not making that payment, and that's exactly what Justice Borick said. He said, okay, so the borrower doesn't have to make the payment. Big deal, that doesn't affect Ashkenazi. But he's wrong about the second part of that. It does affect Ashkenazi, because the express terms of the guarantee are that Ashkenazi is supposed to pay the borrower's liabilities when the same shall become due and payable. And they aren't due and payable yet. So my submission, Your Honor, is that I should get summary judgment. Forget about 3213. And it is the law, by the way, that even if this is not a good 3213, the court can grant summary judgment for the defendant. That's what the Court of Appeals did in Weissman.
So on appeal, the borrower defendants aren't disputing the amount of the judgment against them. You know that, right?
I'm sorry, Your Honor. I'm having...
I know, it's so hard. On appeal, the borrower defendants are not disputing the judgment. They're only disputing the interest.
Those are, well, these are not borrower, Mr. Mielef's clients are not borrower entities. They're the other guarantors.
I'm sorry, the other guarantors. You're the only guarantor that is disputing both liability and the interest, correct?
Correct.
So why are you different from the other defendants? But the other guarantors?
The other guarantors are right in the loan agreement. It says that if the payment isn't made 5 years out, then the plaintiff can move against the collateral of the other guarantors. Chose not to do it, but it said they could. Mr. Ashkenazi is not even mentioned in that paragraph. So he's in a very different situation from the other guarantors.
So your position is really that then if that $20 million is not satisfied by the other guarantors, then it adds back to the principal and becomes due when the principal is otherwise due under the original loan?
Yes, due at maturity.
And Mr. Ashkenazi could conceivably be on the hook at that time.
Conceivably, quite like any other guarantor. It's a point of a guarantee. He's on the hook if the borrower doesn't pay. Thank you.
Okay, thank you.
Good afternoon, Your Honors. Thomas Mielef, Nixon Peabody, on behalf of the appellants 257 Church Holdings, BA 616 Collins, and Leeds Capital, LLC.
So, just to clarify, so you agree that Mr. Ashkenazi stands in a different position relative to the non-payment of the $20 million than your clients?
He does, Your Honor, because of the provision that Judge Smith referenced, where it says that if the payment wasn't made, that the lender could then act against collateral that was pledged by the other appellants.
There were immediate remedies against your client for the non-payment of the pay down amount.
Correct, Your Honor. And so it's very different from Mr. Ashkenazi, who is not included or mentioned at all in that operative provision. And just briefly on the issue of interest, the court below improperly issued statutory interest in this case because there was already interest effectively being accrued against that same $20 million.
Well, isn't that true on any kind of loan or any kind of commercial transaction which calls for the payment of interest?
So I think, no, Your Honor. So I think the law is clear. Contractual interest governs if the loan is still outstanding and hasn't been merged into the judgment. Here, the loan exists. The loan is not due and payable until 2023. The $20 million that was not paid is still within the outstanding principal balance of the loan and is still accruing contractual interest at the rate of 6% and effectively 10% after an internal rate of return is also included. So the law is clear. Under those circumstances, the lender is getting its interest. It's getting its 6% contractual interest because the loan still exists. The cases which the lender, the appellee, attempts to rely upon are totally distinct. This is not a promissory note where there's periodic payments that are principal and interest. The law says you need to be compensated for not having your money, right? This is not about penalizing the appellants here. The lender is being compensated for not having its money because it is getting interest as part of the outstanding principal balance of the loan.
But it's not the interest it would get because of the default, right? You're not disputing there's a default. And that default interest rate is not the contract rate.
No, Your Honor. That's because the loan still exists and hasn't been merged in the judgment.
But the real deal is that the
That $20 million,
Plaintiff is not getting the benefit
yeah,
of what it's supposed to get because you defaulted. So essentially, you have nothing happening
no,
because you have, as if you didn't default.
no, that's
correct?
incorrect, Your Honor, and it's incorrect for two reasons.
Why?
One, once again, the loan still exists. That same $20 million is currently accruing interest. It is going to accrue interest until the time of maturity in 2023.
And that's because it's been added back to the principal.
It never left. It's there. And not only is it getting interest, it's getting interest upon interest. The $20 million would have served to pay down the loan by $20 million. It was not paid. It is still there. It is still accruing interest, and it's accruing compound interest, interest upon the interest. Just one other thing.
No, wait a second. When you pay this judgment off, it's not going to be part of the loan anymore, correct?
When we pay this, well,
So you get a judgment, you're going to, either you pay it or you don't, but if you pay it down, it's not the part of the judgment.
and until the judgment is paid, Your Honor, the interest that would have been accruing during that time is still was accruing during that time at 6% and the contractual rate.
But not as to you. As to you owe the money now, not later. You owe the money today.
But
That's
Your Honor,
what Judge Bork said. You owe
can't-
the money now.
but the law doesn't say that, Your Honor. The law says they can't.
The law doesn't say that.
It doesn't say, well, there's one thing that I would like to get to, but on that point, Your Honor, this is a guarantor of a loan. The obligations of the guarantor cannot exceed that of the borrower. Here, what you're suggesting, Your Honor, would be that the borrower is paying the 6% effective 10% interest, right? Also, what's being tacked on is an additional 9% statutory interest on that loan, because they're already paying the 6%, which rises to 10%. The other thing I just have to say, Your Honor, in addition, there's a late payment charge that was actually assessed against the guarantors here. That's 5% of the amount owed. And it was specifically said, Your Honor, and the words in the agreement were, it's to compensate lenders for the loss of the use of such delinquent payments. This was assessed by Judge Borak against the appellants. He has assessed effectively the contractual penalty for failing to make the payment. That has been already assessed against the appellants. The addition of statutory interest, in addition to not only the late payment charge, but also the fact that that same $20 million is to this day, and has every day since the payment has not been made, accruing interest, means that the assessment of statutory interest was an additional penalty that is violative of New York law.
Good afternoon, Your Honors. May it please the Court. Janice McAvoy from Fried Frank on behalf of the plaintiff respondent, Talos, the lender here. Ashkenazi is mixing up the concept of when the 5-year paydown amount was due and what the lender's remedies were against the borrower if it wasn't paid. The loan agreement is crystal clear about when the payment is due. Section 2.4.8 says, on or before the 5-year paydown date, borrower shall, mandatory, shall prepay the 5-year paydown amount. That's the when it was due. And as Mr. Mielif just noted, he acknowledges that a late fee is due because that amount was not paid when due.
So what did it mean under the agreement when it said that notwithstanding anything to the contrary, the borrower's failure to make the 5-year pay down on or before the date, and they call it a payment default, shall not be a default under the agreement? What was meant by that?
Exactly, Your Honor. That is the remedy.
Exactly.
The parties,
What does it mean?
It means that the lender's remedy is that it cannot declare a default against the borrower for failure to do it. Instead, it can go after the guarantors.
It had a contractual remedy, right? And clearly, the LLC guarantors are conceding that the contractual remedy against them at that time was effective. Why was it also effective against Mr. Ashkenazi in terms of his agreement?
Because Mr. Ashkenazi and the entity defendants guaranteed exactly the same thing. If you turn to Ashkenazi's guarantee, It's in the record at 230. It defines guaranteed obligations as, quote, all obligations and liabilities of borrower to pay the 5-year paydown.
Wait a second. It says, if the borrower defaults on the paydown date, then plaintiff can exercise its remedies under the payment guarantee and then the payment guarantor pledges. It doesn't say anything about Ashkenazi's guarantee.
That's the mezzanine.
So if you wanted to, you could have said, and Ashkenazi's guarantee, but you didn't, right?
Well, but there's a reason for that.
Let's agree. Let's just
Yes,
start with
agreed,
it's
agreed
missing.
completely.
It's not there. What your remedies are against other people.
But,
It
Your
says
Honor,
nothing about him.
There's a second separate remedy, and that is the Ashkenazi recourse carve-out guarantee. The reason that he's not mentioned in there is he is only liable if the pledge entities did a bad thing. It's a recourse carve-out guarantee that has to be triggered by a specific event. It's not automatic. However, Ashkenazi concedes that event was, in fact, triggered. That bad act
How could he
happened.
concede it on a 3213 motion for summary judgment in lieu of complaint?
It's on page 11 of his brief, Your Honor.
A
his
brief
opening
is
brief.
not, a brief is an argument,
Well,
right?
we established it in our prima facie case by demonstrating that, in fact, the entity guarantors had taken out a
You're saying as a
loan.
matter of law, there was a bad act and that you established it and then you're arguing, but yes, it's a 3213 motion even though you have to establish a bad act?
Your Honor, courts have routinely dealt with this in UBS against Garrison and B of A against Lightstone. It was a non-recourse trigger event, a bad boy act. In those cases, it was bankruptcy, and the court said it doesn't matter that you have to look outside as long as the contingent event is a readily identifiable event. Those were 3213 summary judgment in lieu of complaint cases, Your Honor, where the court said absolutely. If a bad boy can be easily ascertained, you're entitled to summary judgment in lieu of complaint.
And what did you allege was the bad boy act that triggered the carve-out?
That the church and the Collins pledgors obtained a loan without lender consent. The collateral that they had pledged to us to cover this $20 million paydown, they went ahead and loaned it to someone. They pledged it to someone else.
And you're saying that's an Ashkenazi bad boy
That is
event?
exactly an Ashkenazi. There's no dispute about that. Ashkenazi admits in his papers, he poses it as the question presented. It's not whether or not he's liable, it's when. And the question of when goes to his guarantee. And Your Honor, what I was reading before, the loan agreement specifically refers to the remedies of going against the guarantor. But in Ashkenazi's guarantee itself, at page 230 of the record, it says he is guaranteeing if certain events happen, which he concedes have happened, then the guaranteed obligations are defined as all obligations and liabilities of borrower to pay the 5-year paydown. And then if you look to the entity guarantee, and that's at page 214 of the record, there, the guarantee is exactly the same thing. They've guaranteed, I'm quoting, the guaranteed obligation means one, borrower's obligation to pay the 5-year paydown. They have both guaranteed it. The mezzanine loan agreement allowed lenders specific immediate remedies. The separate guarantee of Mr. Ashkenazi, if it was triggered, is exactly the same. And it was triggered, he concedes it was triggered, and we established that it was triggered.
Although your time is up, I'd like you to take at least a minute to address the interest issue.
Absolutely, Your Honor. And I think Justice Scarpula really hit it on the head. We did not get the money when we were promised from this guarantor. And the Court of Appeals has addressed this issue in NML Capital against Argentina and Spodek. In both of those cases, there were periodic payments. One, it was periodic payments of interest and principal. In the other case, in the Argentinian case, it was periodic payments of interest. And the court said an award of statutory interest is appropriate in those instances because the lender is getting compensated for the loss of getting the money when it was supposed to get it. And instead, the guarantor, Mr. Ashkenazi, has kept that $20 million since 2018. He's been able to invest it. He's been able to profit off it. And as the Court of Appeals also held in Love versus State, there's nothing unfair in requiring the defendant to turn that profit over to plaintiff. Okay. Any further questions, Your Honor? Thank you.
Okay, Your Honors, I hope it's clear that I am indeed disputing that Mr. Ashkenazi is liable for a dime today. I am not disputing that he will be liable, that he is on the hook on the guarantee, and that if the plaintiff is not paid in full in 2023, Mr. Ashkenazi owes $20 million of the money.
Are you conceding that there was a default of relating to the refinancing? I mean, counsel said you've conceded that there was a default with respect to refinancing of the Collins property, which would then put you in default in the carve-out. I thought that was a sort of abandoned on appeal, but okay.
I do not concede a default. I do concede that a triggering event in the form of the refinancing of the Collins property did occur. That's why I'm saying, yes, if you get to 2023 and you can't get your money anywhere else, you've got a guarantor, and his name is Ashkenazi. That's a perfectly reasonable reading, and it happens to be the only one that conforms to the text of the guarantee. Ms. McAvoy says, oh, well, why aren't the payment guarantors saying that? Because they have similar guarantees, but the payment guarantors are mentioned right in the loan agreement. And it says right in the loan agreement that if you don't pay in 2018, you can go against the payment guarantors. It doesn't say that about Ashkenazi.
So I'm asking you, are you saying that the default in the relating to the refinancing didn't trigger an immediate requirement that you pay?
For us to pay, it did not. Clearly did not. It triggered our guarantee. It put us on the hook for the guarantee. But an immediate requirement, no. It says right there. It doesn't say when and as the payment guarantors have to pay. It says when and as the borrower has to pay. And the borrower clearly doesn't have to pay to 2023. And that's why she didn't sue the borrower. The borrower's not even a party to this case. Thank you.
Thank you. Thank you all. Okay, the last case today is Deutsch against City of New York.
Good afternoon, Your Honor. Ryan Battisi from McElroy Deutsch on behalf of Appellant Hellman Electric and John Martuskelli. This is a simple appeal. It's a personal injury action. The lower court should have granted summary judgment for the defendant. As the court properly held, plaintiffs did not submit any evidence showing that my client's truck went into the bike lane prior to the accident. This appeal comes down to two issues. Does plaintiff's testimony that he was struck by the truck raise a triable issue of fact? We would say no, as plaintiff admits that he never saw the truck prior to the accident. That demonstrates that that testimony has no probative value.
Well, he did say I remained in the bicycle lane the entire time. And so an inference to be drawn from that is that the truck must have entered the bicycle lane.
Well, inference may be drawn with that, but when it's coupled against the four separate witness testimonies that he fell into the vehicle lane, along with the accident reconstruction expert affidavit that confirms it's physically impossible for this flatbed truck to get into the bike lane and strike the plaintiff. All right, the second issue with this appeal is whether or not Nick Bellizzi's affidavit with regards to the duty of maintaining a buffer lane within a vehicle traffic lane is enough to raise a triable issue of fact. Again, we would say no, there's not that duty under the New York law at this time. It's a new created duty. So unless there's any other questions, we'll yield our time.
Thank you.
Good afternoon, Your Honors. May it please the Court. Lisa Como for the plaintiff respondent. There are clearly disputed versions of how this accident occurs. I don't think there's any question about that. Obviously, the plaintiff said he remained in the bike lane the entire time, that he was hit by some portion of the side of the truck. Mr. Marticelli denies that he ever came into the lane. There are those different versions of what happened at that point. However, there are so many questions of fact that are not resolved and cannot be resolved by really the central piece of proof that they offered, which is this accident reconstruction on paper. And my colleague just stated that it was established by that report that it was physically impossible for the truck to have entered the bike lane at the time of the accident. That's one question. There's also another one, which we'll get to. But as to that question, I would submit that that report established no such thing. All it showed was that there's a photograph of a skid mark, there's a photograph of a truck that admittedly had been moved by the time that photograph was taken.
Who admitted that the truck had been moved?
Mr. Marticelli stated that it had been moved.
He said that he moved it where?
Well, he had to move the truck because it was on top of the plaintiff.
Well,
yeah.
but
So
wait a second. He moved it to the rear. He backed it up a little bit so that the wheels would come off the plaintiff. But in terms of where on the road the truck was, the truck didn't move from the location in the lane that the truck had been in.
Right. No, I'm not implying that it was in a completely different location, but the point is that, number one, this roadway curves. The truck, there's a skid mark from a rear tire. Where was the front of the truck at the time of the accident? Was it moved exactly straight back? Was it moved on an angle? There are definitely questions of fact that are not answered and cannot be answered with this type of reconstruction report on the proof that's in the record. And even more importantly,
But there are eyewitnesses who saw the truck, and they said it never left the lane. So then you have to provide an issue of fact to show that it did, or otherwise support the theory of your expert who accepts that it stayed in its lane and has this theory about the 3-foot buffer, right?
Well, two things. One is obviously, as was just pointed out, if the plaintiff is correct that he was still in his bike lane and he was struck by the truck, then that is a disputed question.
But he didn't really have, he couldn't tell, once he got hit, he didn't know where he was. I mean, that seemed pretty evident. He just surmised that he was in his lane at the time of the accident. He didn't really have any specific observation or recollection of that. He just surmised it.
Respectfully, Your Honor, I think that he clearly stated at both his statutory hearing and his deposition that he was within that bike lane and that the truck hit him and not the other way around. But even more importantly, and aside from any expert proof, even aside from Mr. Belizzi and aside from this other accident reconstruction report, there's something here that's really troubling and that a rational jury needs to consider and would be entitled to find liability upon, and that is this. The lane of travel is 17 feet wide. The truck is 8 feet wide. The bike lane is immediately adjacent on the left side of the vehicle lane. It's fairly narrow. It was congested. There were a number of bicyclists. Under the vehicle and traffic law, you have an obligation as a motorist to use, it's the basic 1146. You must use due care to avoid colliding with bicyclists. You have to sound your horn to warn them. A reasonable jury, regardless of any expert proof at all, could clearly find that Mr. Marticelli did not act reasonably, that he did not safely operate his vehicle because he was admittedly hugging the bicycle lane. He's hugging that line. There's no physical barrier in between. He has all of that room.
Why is that a deviation? Why is that what duty was he derelict in being close to the side?
He admitted in his deposition testimony that it was pointed out that the plaintiff didn't see him, but he saw the plaintiff. He admitted that he saw the plaintiff approaching up the left side in his side view mirror. I think that a reasonable driver is required, especially when you see that it's congested. There's no proof that there was anything else to his right or anything he needed to stay away from on the right. And he has 9 more feet of room. When he sees the plaintiff approaching in his mirror, and he was watching him, he actually says he saw this whole thing. I think that there has to be a duty and a question for the jury to resolve as to whether a driver who sees somebody under these circumstances to at least move over a little bit.
Wait, you're saying anytime you think there's a duty, anytime you see someone in a bike lane that's next to you and on any, just a bike lane, that you have to swerve to your right or move to your right? You can't just drive in your lane?
Actually, I think...
Where do you get that from?
From reasonableness, Your Honor, from safe, when there is all of that space, and you know...
On every bike lane in New York, you have to move over if you see a bike in their lane and you're in your lane?
I think it's clearly dependent on the facts of the case.
Okay.
But when you see, and he also said that the bicyclist was approaching fast. There's other questions of fact from the other witnesses. Did he zip, in front of the other CPC
your client
vehicle?
clearly said he went to his right to avoid something quickly. He made an evasive move quickly in order to avoid something in front of him, whether it was people who were standing there or other cyclists, unclear. But
No, he said he was within the lane. He said he was avoiding people and he was within the lane. Right.
So again, I'm not really understanding it. So the driver had a duty, if he pulled over and he's still in the lane and the driver's in his lane, the truck should have pulled over for what?
Not have pulled over and stopped. It's just that under the
I didn't
vehicle and
say
traffic law,
stop.
under the vehicle and traffic law, you have an obligation to use due care. And I think that in a juror's everyday experience, when you see bicycles, there's a congregation of them, and it's possible to give them some space because people fall off bicycles for any number of reasons. So that even if he didn't cross into the lane, which I don't concede, I don't think that they've established that he didn't. But even if he did not, a jury could find and should be entitled to consider whether it was reasonable under the circumstances and whether it was safe for him to drive so close to that dividing line, knowing it's an exceptional risk of a bicyclist. They're balancing, they're riding, they fall for any number of reasons. And I think that under the vehicle and traffic law, it's sort of a unique case. I don't think either side has cited anything that's particularly like these circumstances, but I respectfully do submit that the jury should be entitled to consider whether having all that space, moving so close to the bicyclist, that he should have done something different.
Okay, thank you.
Thank you very much.
Bo?
The only thing I would say in rebuttal, Your Honors, is that that duty doesn't exist under New York law at this time. All right, if there's any questions, otherwise we'll rest. Thank you, Your Honor.
Yes, sir. In the morning. Are you in tomorrow, right? Yeah. I don't know, Greg. I'm not sure if he just dropped them off and then waiting for them. I know they make